Okay, so today we're going to do our practice end of course exam. We're going to go question by question, read the questions, read the answers. You're going to decide what you think they are, and then I'm going to explain to you why it's what it is. So we'll go question by question all the way through from 1 to 100. Okay?
Amen.
Cool. All right, so let's start. A licensed real estate broker has been hired by a lender to appraise a home for a buyer who has applied for an FHA loan. Which statement is true regarding this situation? A, the broker's license entitles him to appraise the property. B, the broker may not charge for this assignment. C, the broker is required to be a state certified appraiser to perform this appraisal assignment. D, the broker may not accept this appraisal assignment because to do so is a conflict of interest.
So since this is a FHA loan, which is an unconventional loan that is backed by the federal government, the answer is going to be C. The broker is required to be a state certified appraiser to perform this appraisal.
Absolutely correct. Now, if it wasn't federally guaranteed, different.
You could.
Right. Exactly.
Yeah.
So that's good. Now you know the difference of that. So if that question is asked and they change the words around where it's not an FHA loan, you know the other. See, that's why I want to go over this with you. I'm going to show you the answer and how it can adapt, right? Depending how you see it.
Amen.
So let's go to number 2. Which disclosure must be given to the buyer of both new and resale residential condominium units? A prospectus, B, a governance form, C, an estimated operating budget, or D, a declaration?
This one was pretty interesting because this one, in all those answers, or the majority of those answers, are given to either one of them, but not to 2 of them.
Right.
So in this case, the answer is going to be D, a declaration form.
Correct.
Yeah.
Well, here's the thing. It's new and resale.
Yeah,
So
that's why. Yeah.
Right. So an operating budget is available. The governance form is available. You know who's on the board that's already operating. A prospectus, no, because it's not being built. A prospectus is only when it's being built, right?
Yeah.
It's not living in yet. And a declaration has to be both because that's the actual declaration of the condominium. So
Amen.
Process of elimination on that one, right?
Amen. Yeah.
Good. Let's go to number 3. An individual who typically finds a tenant for property and collects a fee is referred to as A, an absentee owner, B, a property manager, C, a community association manager, or D, a rental agent.
We, of course, know that the answer is an absentee owner. I'm just kidding. It's a rental agent.
Right. Because you're finding them. You're a property manager actually manages it after they rent too, right? They collect the payments, fix the property. So that's the difference. Okay.
Yep.
Good. And the other 2 you could just throw out because they don't make any sense.
Right? Yeah, absentee owner. That's not at all.
And that's one of the techniques you want to look at on the test. You want to look at the question and you say, okay, well, it can't be A, it can't be C. So it has to be out of B and D. And then you use process of elimination of your knowledge, right?
Mm-hmm.
So that's a little trick. So let's look at number 4. Failure to comply with the statute of frauds will result in A, a charge of fraud, B, an illegal contract, C, an unenforceable contract, or D, a revocation of licensure.
So on that one, I put D, but I know it's wrong.
Correct. Statute of frauds is what regulates contracts.
Therefore,
contract's valid or not, right? If you do a contract with somebody who's 17 years old, no, unenforceable, right?
Yeah.
If you do a contract and they miss a signature, no, not executed, right? If it's more than 12 months and not in writing, right? All those rules. Remember we talked about those?
Yeah, we did.
So a charge of fraud, you could throw that one out, right? That's just kind of trying to confuse you because the statute of frauds. Revocation of licensure, no, because this has nothing to do with license law. This is contractor, right? It could be either B, an illegal contract, or D or C, an unenforceable contract. So when we talk about contracts, we didn't really talk about illegal contracts, right? They're kind of putting that in there to make it illegal, you know? So the correct answer, the best answer is what? C, an unenforceable contract, right?
Unenforceable contract. Makes sense.
That's like doing a contract with somebody who's 17 years old, or a contract
Unenforceable.
not signed. You missed initials, right?
Yeah.
That's unenforceable. Good. So let's look at number 5. Which property is not covered under the Fair Housing Act? A, multifamily housing of 5 or more units. B, a commercial property. C, government-owned residential property. Or D, privately owned residential property listed by a broker.
On that one, I put A, but I know that's wrong.
Do you know why that's wrong?
I do not.
It's residential. It could be 100 units in residential. It still applies because it's residential.
Oh, so as long as people reside in it, it's, oh, okay, gotcha. Well, in that case, it's B then.
Correct. Any commercial property is not covered under Fair Housing Act, so you don't live in your commercial property. Right?
Got it. You're not supposed to anyways.
Not supposed to, but yeah, I mean, it's, what it is.
I got you.
Okay. Let's go to number 6. A broker received a $5,000 deposit from a buyer on Tuesday at 1 p.m. The seller will not be available until Monday. The broker's normal banking day is Monday. The broker is required to deposit the $5,000 before the end of which? A, the next business day. B, business on Wednesday. Business on Thursday. Business on Friday.
Well, in this particular case, the broker received the money on Tuesday at 1 p.m. So that date does not count. So it's going to be, and it's usually by the end of the 3rd business day. So we have Wednesday, Thursday, and Friday. So the answer is D, business on Friday.
Absolutely correct. Now, when does the agent have to give it to the broker?
By the end of the next business day.
5 p.m., right? So that would be
5 p.m.
Right?
What is it?
That would be on Wednesday.
That would be, yeah, by Wednesday 5, yeah.
Right. Now, what if there was a holiday on Friday? What would happen?
Then it would be by Monday at 5.
Right. Holiday doesn't count. Correct. Okay.
Yeah.
I'm trying to give you different scenarios, like how you would see something like that, right?
I like it.
But you got it. You're good. All right.
Thank you.
Let's go to number 7. Which expense is subtracted or derived from net operating income? A, vacancy and collection losses. B, mortgage payments. C, income taxes. Or D, depreciation.
It's going to be A, vacancy and collection losses.
Right? Because you go from the potential gross income and you subtract, and you have to find out what the effective gross income is, right?
Yeah.
And then you get to your effective gross income minus, your operating expenses, and there's your NOI, right?
Yeah. What are collection losses? Because I found that one out.
Very good question. You lease an apartment, they don't pay you rent for 2 months.
Collection losses. That makes more sense now.
Yep. Right. But also remember, you have to add back in the vending machines and the washing machines. Remember the other expenses?
Oh,
they put that there.
Yeah.
Just for purposes to know, right?
Yep.
Okay, let's look at number 8. Okay. An investor wanted to build a motel. A broker showed him 3 choice sites zoned hotel motel. The investor promised to decide on a site in 3 weeks. The broker took a 2-week vacation. When the broker returned, the investor bought one of these sites. The broker sold the site, not knowing that the zoning on that site had been changed to industrial. Which is correct? A, the broker is guilty of culpable negligence. B, the broker is not guilty of wrongdoing. C, the property owner is guilty of fraud. D, the broker is guilty of fraud.
That one I didn't have much clue of because they all look like, I don't know, they all look similar, or they all look like it could be possible. I don't know, like in this situation, I don't think we went over that too much. But upon thinking about it, and seeing some things, I saw that the answer was A. But was it because the broker was supposed to do the due diligence on that property and to see, what the changes were and all that good stuff?
Correct.
Therefore, he will be the one that will be in the wrong.
Yep. So that makes sense. The broker has a responsibility, right? Skill,
Yeah.
care, and diligence, right?
Yeah.
That's not skill, care, or diligence, right? Diligence and skill.
Gotcha.
So now look at what's wrong with them. Which ones do you think it is? If you had to eliminate those and make like the best guess you could, what do you think it would be?
Well, the property owner is not guilty because they just changed whatever they had to change. I mean, it was the broker's job to, see that and do due diligence on it.
Mhm.
The broker being guilty of wrongdoing, I don't think we talked about wrongdoing on broker. That doesn't seem to be a term. So it will be either the broker is guilty of fraud or the broker is guilty of culpable negligence.
Mhm.
And for fraud, I think the definition was that the licensee would say something inaccurate. The client of the licensee would take said information and would make a decision based on that information. So he would rely on that. And then the third one was that the client would be hurt by
Hurt in a heart. Hurt.
making,
Yep.
yeah, will be hurt by making this decision. I forgot what the fourth one was, but even then, I thought that's what that was. I thought that's what it
Third one
was.
is the client acts on the information, and
Yes, the client acts on the information, and the client it's affected negatively by this action.
do you remember
Uh,
culpable negligence? That's when you're careless, or you say
mm,
it's not true, or you just it's ignorance, really, right?
yeah. So in this case, it'll be more of a culpable negligence,
Right.
unless the person asked and the broker said, oh it's good. You can
Right.
buy it, sign the documents.
Remember, yeah, exactly. But in the question, it says at the time they looked at it, it was zoned
Yeah,
hotel, and then it changed while he was on vacation.
So he
So
didn't know that he was wrong.
right. So he did do the research. He did check it out,
Yeah,
but he should have checked it out. Now the guy bought the property when he was on vacation. I mean, there's
yeah,
still, but he's still liable,
yeah,
right? So answer is A, culpable negligence. Fraud would have been if he knew it was
yeah.
industrial and told him, yeah, you could buy it.
Or if he had any idea.
That fact, if it was
Yeah,
that, if he knew it ahead of time and let it go, that's crossing the line of fraud.
gotcha.
You can still be in big trouble for both. I mean, you still lose your license for both of them, right?
Got it.
But that's something you must make sure is okay, right?
Got it. And question for you.
Yep.
So just like the property owner changed hotel motel to, I don't know, I forgot what it was that they changed it to. What is it that he changed it to?
Industrial.
Industrial.
Oh, industrial. Okay. So just like they did that, wouldn't the client be able to do that as well? Or would that be so much of a hassle?
It could, but there's process and a lot of expense to that.
Uh,
And it caused him a harm,
yeah,
right? Because he wanted to keep it like he was investing in that, right?
got it.
It's not that it could be or couldn't be. Maybe it can't be, you know? So
All right, got it.
let's go to number 9.
Someone's telling you they're buying an here's an apple for you to buy. You give them $5 and they hand you an orange. It's not what
Yeah,
you're trying to buy.
No,
You're
it's
trying to
still a
buy a
fruit.
hotel motel, not industrial.
Yeah, I got it. Still a fruit though.
Okay, number 9. Which clause is included in a mortgage to prevent a subsequent buyer from assuming an existing mortgage? A, an acceleration clause. B, a defeasance clause. C, a due on sale clause, or D, a prepayment penalty clause?
So definitely not prepayment, because that's just whenever you're paying something quicker than you should. Definitely not acceleration clause. Acceleration is when you are delinquent on a mortgage, and you are and you would pay all those penalties and all those things so that your which I'm calling, so that your mortgage can be reinstated, I think is what it's called. That B one, I have not heard of that one in my life, so it will be C.
Correct. You got that good. You did good. Okay, so you eliminate. You don't remember defeasance clause?
I do not. Defeasance? No.
Defeasance clause basically states that it's a provision that allows the borrower to pay off their outstanding loan without penalty or additional fees.
Oh.
You can pay it off at any time you want without any penalties or additional fees.
So defeasance is how you pronounce it?
Defeasance.
Defeasance. Okay. Yeah. So that would be the opposite of the repayment penalty clause, I guess.
Yeah. Well, yeah. Yeah. So due on sale clause. Yeah, exactly. Defeasance clause means it's opposite. It's the opposite of a prepayment.
It's the opposite of repayment.
You
Yeah.
won't have both of those. You could either have that or you want to have both, right? Because they're conflicting.
Got it.
But the due on sale clause means it has to be paid at the time of transferring the deed. Okay.
Amen. Amen. And it's paid by the title company.
Yes. Yep. They get the
Amen.
payoff. They wire the money to them at closing, and it's done at the time. Yeah.
Amen. Like it.
Okay. So number 10, within the period of time within what period of time must landlords of 5 or more units notify the tenants in writing of the method used to hold security deposits? A, 3 days, B, 15 days, C, 21 days, or D, 30 days?
On that one, I confidently said 15 days.
Mm-hmm.
But what's the correct answer, my good sir?
It's actually D, 30. When they own more than 5 units, it's different than than the normal situation. So if this is when you got to let them know what bank's holding it and what type of account it's in. So when you own more than 5 units, you must let them know within 30 days where the escrow or their escrow funds are being held and what type of account it's in.
Got you. And also, if you are getting any interest on that, I guess that should be also in that.
It'll also be, disclosed, and you have to tell how the interest is. Are you giving it to
How
them?
the interest?
And they have to, right? So that's the whole process. Yeah.
Got it. Got it.
All right, let's go to number 11. The seller instructs the listing broker not to show his home to members of a protected class. The broker informs the seller that this is a violation of fair housing laws, but the seller is insistent. Which choice is the broker's best course of action under these circumstances? A, report the incident to the Fair Housing Administration. B, report the seller to the DBPR. C, withdraw from the listing agreement. D, follow the seller's instructions, because to do otherwise would violate the broker's fiduciary duties to the seller.
On this one, I confidently said A. But as we know, it's not necessarily correct.
Well, the answer is C, right? You can withdraw from the listing agreement. Now, you can report them to the Fair Housing Administration, but there's nothing that says you have to legally, right? Reporting to the DBPR regulates license law. They don't regulate federal law.
That's what I thought.
Which follow the instructions. Now, when you're in a fiduciary relationship as a single agent, you must obey, right? Obedience, right? Is one.
Yeah.
However,
as long as it's legal.
not breaking the law.
Yeah.
You can't break the law. They're trying to trick you on that one, right?
Yeah, definitely.
Trick you on that one, right? So that's not that one. Now, the only thing you can do is withdraw from the listing agreement.
Yeah. So you can report the incident to the Fair Housing Administration, but it's not something. It's not something that you must do, I guess.
Right.
Okay.
Correct.
That's what I went.
But that's
I
how
was
you
like, yeah.
questions. That's a possibility. It's not that it's wrong. It's just not a legal requirement. It's not what you wouldn't, you have the right. It's asking what is your best course of action is to remove yourself from it. Right?
Okay.
Okay, let's look at number 12. A buyer or seller must be given a brokerage relationship disclosure for which transaction? A purchaser of an auction residential property. B, owners who list a 10-unit townhouse property. C, purchaser of 15 acres of land zoned for 15 residential homes. D, a purchaser of a single-family home working with a single agent buyer's broker.
A purchaser of a single family home working with a single agent buyer's broker.
Absolutely correct, right? Because on the other ones, you're already assumed what? A transaction broker, right?
Transaction broker, yeah.
Right? But when you have somebody who's a single agent buyer's broker, you must have a form and a relationship disclosure for that transaction.
Got it.
Okay, good. Let's look at number 13. A woman who has homesteaded her residence. I'm sorry, a woman has homesteaded her residence. Her home has an assessed value of $279. She is a non-veteran who is totally and permanently disabled as a result of serious car accident. She is also legally blind. What is her cumulative county tax exemption on her homestead? Okay.
This one was pretty hard.
Remember, this test is 500, not 5,000, right? Because for the answers. Okay.
Yeah.
So, you have a pen, paper?
I don't need it.
You don't want to do it? You don't want to do this one? Okay.
I don't need it.
Okay.
I don't need the pen. It's just three numbers.
Go ahead. Okay.
Yeah. Use three numbers. I don't get me wrong. I did do. Let me show you because I may have sound like I.
Well, I want to go. Let's go over it for the recording so we have it.
Okay, you see this right here?
Yep.
All this is all the notes and all the math that I was doing as I was doing all that, and I was just writing.
Let's go over it for the recording. Let's go over the numbers and verify you got it. You're
good. Definitely.
You did great with the math. So.
Oh, thank you. So yeah, this one was pretty hard because I didn't read the question properly, and I was trying to understand what her taxes were going to be as opposed to what her accumulative
They're just asking what the amount you're saving is.
Yeah.
Right?
Yeah. Well, in this case, so since the property is over $75,000, then it's just gonna get a $50,000 deduction just because of that.
25, correct. Good.
Yep. And then she is also permanently disabled.
Non-veteran, right? If it was a veteran, it'd be 100%.
Yeah. It'll be nothing. Yeah. And then she's also legally blind. So for each one of those, it's gonna be 500 in this test. But then in the updated one, it's gonna be 5,000 per each one of those.
Right.
So those 3 digits pretty much make 50,000, 500, 500, 5,100.
Right. And in current day,
51,000.
51,000. And in current day pricing, it would be 500 or 5,000. And 5,000 or 50,000 and 5,000 and 5,000. So it'd be 60,000 if it was today's problem, right?
Amen.
Okay, just want to make sure we're clear on that.
Oh yeah, definitely.
Very good. Let's go to number 14. The duties of a real estate licensee owed to a buyer or seller who engages the real estate license as a single agent do not include A, dealing honestly and fairly, B, limited confidentiality unless waived in writing by a party. C, presenting all offers and counteroffers in a timely manner unless previously directed otherwise in writing. D, loyalty. Which one is not?
So for a single agent transaction, you definitely want to be dealing honestly and fairly. You know, that's just what you do with all of them, actually.
Remember, add is in all of them, right?
Yeah, add is in all of them. Yeah. Amen. Present all offers, definitely. You wanna be as transparent as you can with them. Loyalty, definitely. Actually, full loyalty is the actual
No,
um,
disclosure, full disclosure.
in full disclosure as well. Yeah.
Loyalty,
Um,
though, remember cold. Confidentiality, obedience, loyalty, and full disclosure. Cold.
yep.
That's the
Cool.
right?
Yeah. Yeah.
Works
So
similar.
in this one, the answer will be B, limited confidentiality unless waived in writing by a party.
Right. And that because that's a transaction or that's a transaction broker, right?
Yeah.
Remember, because you can't be limited and full at the same time, right?
Yeah.
Right. Good. Very good. Let's go number 15. Which entity is a primary mortgage lender that does not accept demand deposits? A,
That one,
B, mortgage lenders, C, savings association, or D, credit unions?
I do not know, to be honest with you.
Do you know what demand deposits are?
I do not.
Depositing money into your checking and savings. So which one of them would not take deposits?
Oh, that's what it is. Okay.
See how easy it is now?
Yeah, I mean, yeah, if they will frame it that way, yeah.
So what do you got?
So commercial banks definitely, because Bank of America takes my
Yeah.
money every time I give it to them. Credit unions, of course. So that's two out of the way. Saving associations and mortgage lenders. Saving associations, I mean, I think that's what they do. Like that is what their job is, taking
Hey, if you give it
deposits.
money to save.
Yeah, that's what they do. Otherwise, how they gonna get the money? So yeah, it will be mortgage lenders in this case.
Right. Mortgage lenders is correct. Like, think about this: Rocket Mortgage, all these Quicken Loans. Remember, they have to have the MLO license numbers. Remember, they have to have those special licenses for the loan officers when the other ones don't because they're federally regulated because of the deposits in the banks.
Yeah,
We talked about that.
we did talk about that. Yeah.
Yep. So the credit unions, savings associations, and banks all take deposits, and they're all federally regulated. Mortgage lenders are the ones who need MLO licenses, and they have to register with the federal organization. And mortgage lenders are the only ones who do not take deposits, right? They handle just with mortgages. So good.
Gotcha.
You had to know what the demand deposits were.
Okay. And so when you have business with a mortgage lender and you want to just pay them, you just pay them, but you're gonna actually deposit in there.
Well, it's a servicer you pay. It's servicing. So who you pay as the loan changes banks, a lot of times the servicing stays the same. You're paying them your payment for your mortgage, not any deposits for an account. You don't have any other accounts with them.
Gotcha.
That's different. Demand deposit is putting money in your account.
Makes sense.
Okay,
Appreciate it.
Okay.
Yes, sir.
Good, man. Let's look at number 16. A sales associate who is employed by an owner developer who owns properties in the name of various entities may be issued A, multiple license, B, a group license, C, a commercial license, D, a branch office license.
In this case, the answer is definitely not a branch office license.
Right? There's another one is definitely not either.
Oh yeah. The commercial license is definitely not that one either.
There's no such
So it would go with either multiple licenses or a group license. And when I went to group license because it just makes more sense to have it that way.
Remember, a group license, it's correct, right? Remember, a group license is only available to a developer who has multiple projects and agents working for them selling those projects. And those agents are allowed to sell the units in all those projects, nothing else outside. But if they have 4 developments, they can sell all 4 developments. That's a group license. Multiple license would be, I own Pier 21 Realty. I want to open 3 other brokerages. Now I have to have multiple licenses to open different brokerages.
Got it.
Broker, right?
Got it.
That would mean I'd have multiple licenses. Okay.
Got it.
Commercial don't exist. There's no such thing, right?
Yeah, there's not.
Okay, 17. A tenant signed a 10-year lease requiring a monthly base rent of $1,900 plus 2% of all monthly gross sales volume over $95,000. The tenant also must pay all property taxes, insurance, and other costs normally considered property owner's costs. This is A, gross lease, B, fixed lease, C, variable sale lease, or D, net lease.
It's gonna be net lease in this case.
Right? It's good. It's a little bit confusing because it's also a percentage lease.
Is it?
Right? Because he's giving 2% of the month.
Oh, yeah.
5. So you got to look at it. Percentage lease isn't in there. So which one is in there? Net.
Yeah.
But that could have been percentage lease too, right?
Yeah.
So just so you got to look at that because sometimes it gets a little confusing. If it's not there, go with the one that's there, right?
Got it.
Okay, good. Let's look at number 18. Okay, a real estate license may be revoked without prejudice for which action? A, culpable negligence. B, failure to account or deliver escrow funds. C, issuance of a license by mistake of the commission. Or D, conversion.
Well, in this one, I did not answer it, but then afterwards I saw what the answer was, and it just makes a lot of sense. I guess the word issuance, which I
Yeah.
might be even saying wrong.
That means they gave you a license.
Yeah, that is the act of issuing
Yeah.
something. Yeah, I realized that after I saw that was the answer. Like after I saw that was the answer, I was like, yeah, Jeffrey, issuing sounds like issue, so it sounds like issuing something.
Yeah.
So yeah, that's what that means. So I just didn't understand. If I would understood that word, I would definitely got it.
Right, being revoked without prejudice, you could actually apply for it. If they gave you the wrong license, you just reapply, right?
Yeah.
Whatever has to happen. Right now, you got to look at the other 3. You lose your license for those 2. Now this is revoked without prejudice stuff. The other ones, you have cases, you have hearings, you're innocent until proven guilty, right?
Yeah.
So you can't just get it taken. Only when they made a mistake, they could take it, right?
Got it.
Yeah, good. That's how you got to look at that, right?
But what is conversion?
Conversion is taking a $5,000 deposit and putting it in your personal bank account and using it.
Oh, I see.
Converting the money to, it's illegal. You can't take money from the account and put it in there, right?
Amen.
All right, let's look at 19. A broker's license was involuntary inactive for 2 years and 1 month. To operate again as an active licensee, the broker must complete 60 hours of the broker's post-licensing education course, 28 hours continuing education, and pass the broker's exam. 42 hours of continuing education and pass the continuing education course exam. FREC 1 and pass the sales associate license exam. FREC course 2 and pass the broker's licensing exam.
Could you help me with this one?
Yep. Okay, so if you have a license and it's involuntary inactive for 2 years and 1 month, to operate again as an active broker, you must complete what? Now, this is a broker's license, not a sales agent, a broker's license. Okay. So what are the rules? Do you remember if your license is involuntary inactive, not voluntary inactive? If you're voluntary inactive, you're okay. That means you took your license, put it inactive, and you continue your continuing education. You're fine. You can do that. Involuntary inactive is when you didn't take your courses and they put you in involuntary inactive.
Got it. Yeah.
You didn't pay your fees. It's involuntary. Do you remember the thing? If it's 0 to 12 months, right?
If it's 0 to 12 months, you do something, yeah.
You do 14 hours, right?
Yeah.
If it's 12 months to 24 months, you must do the 28-hour reactivation course, right? Now, if it's over 2 years, what happens?
You do the.
Oh, you're null and void. You lose all your licenses.
Oh, is that right?
So the correct answer would be C. You got to start over again and be an agent for 2 years before you can be a broker.
Mm.
So you got to take FREC course 1 and pass a sales associate's exam. They throw FREC course 2 to be the broker to try to trick you. But if
Yeah,
you go back to square one.
makes sense. Okay, now I know.
You understand that now?
Yep. So 12 months, you have to do
0 to 12 months. Just do your 14 hours and you're good.
14 hours. Okay.
12 months or you got to do 20-hour recertification course. And then you're okay. But if it goes more than 2 years, you start over at scratch like you were never licensed.
Amen. Okay.
Okay. Number 20. Which individual must hold an active real estate license? A salaried employee of an oil company who buys and sells land on behalf of the company. B, a person who sells timeshare periods for customers. C, an executor of a will who is selling the real property for a deceased individual. D, a person who's employed by Meadow Hill Cemetery to sell cemetery lots.
Okay. So essentially, and this is just my thought process in that one, because I got that one right. So so both A and D, they do not get commissions for what they do. Therefore they don't need a license. That's the way that I look at it.
Cemetery lots. Cemetery lots are void. You don't need the licenses to sell cemetery lots.
Oh, there you go.
Same thing. Yep. Okay.
There you go. Amen. And then the executor of a will does not need a license either, because they're just executing something that is already written by the owner.
They're acting as an attorney on behalf of the client, right?
There you go. There you go. Amen. So it will be B. A person sells timeshare periods for customers.
Right. Now, what if the person worked for the timeshare company and got salary and no commission?
Then they do not need a license.
Correct. But you see how they threw that in there to trick you, timeshares?
Yeah.
So if you're thinking that, you can get that wrong, right? Because if you're working salary, you could do that. But in this question, it doesn't say that. So that's important. That's what you got to think about, right?
Got it.
Good. All right, let's go to 21.
I also heard that they can also put salary plus commissions.
But then you need a license.
Yeah, you do need a license for that.
Anytime you get commissions or bonuses.
Got it.
Okay, 21. Which statement concerning characteristics of the real estate market is false? A, real estate is immobile. B, the market is slow to respond to change in the supply and demand. C, the real estate market is organized and controlled centrally. D, land is indestructible.
That one I answered like it was true, as opposed to being false. False, to be honest. I put B, although I know that B is super true. I remember you saying that.
Fully true. Yeah.
Yeah, it's fully true. That's actually one of the truest that there's there. Although real estate, it's immobile. Real estate, it is immobile.
And pick it up and move it, right?
Yeah, you can pick it up and move it. The land being destructible, I don't know. Like it could be not. I don't know. But I think it's gonna be C. The real estate market is organized and controlled centrally. I don't think it's so organized.
No, it's local, right?
Yeah.
A property on the beach, the market on the beach can be way different than the market 10 miles inland.
There you go.
So
there you
go. Land is indestructible. Land is it's indestructible. The house on it isn't, but the land is, right?
Got it.
That land's going to be there forever. That land stays forever.
Yeah. So I think another example of the market not being organized like that much is that if you own a property and the property is worth $100,000 and you want to sell it for $5,000, then it's your property that you can do that. That's totally fine.
Give it away for $1. You give it away to somebody for nothing. Right?
Yeah, it's essentially. So that's why. That's one of the things. One of the reasons why it's not so controlled, because you get to do whatever you want with your property and sell it however you want. If you want to sell it for $1 million, even though it's not worth $1 million, if somebody buys it, by all means.
Correct. All right, so let's go to number 22. A comparable property has one more bedroom, which is valued at $8,000 and is on a slightly larger lot, which is valued at $2,000 than the subject property. The comparative market analysis requires a net adjustment of minus 8,000 to the comparable property, plus 2,000 to the subject property, plus 10,000 to the subject property, minus 10,000 to the comparable property.
The answer for this one, it's going to be, we're first going to add the 8 and the 2, because that is the difference between our subject and our comparable
Right,
property.
because it has more bedroom and
Yeah.
a larger
And
lot.
larger, yeah. So those are both.
So the number you
larger.
need is 10,000. Okay, so
10,000.
that eliminates A and B then, right?
It definitely does.
Cool.
And then we always change or modify the comparable property as opposed to the subject property. So the answer is going to be D.
Absolutely right.
10,000 to the comparable property.
That's exactly how you look at that. You got that 100% right, man. Good job.
Thank you, sir.
Let's go 23. Which entity may not be registered as a real estate brokerage? A corporation for profit, B, a corporation sole, C, a partnership, or D, a sole proprietorship.
Well, since I have never met a preacher / church pastor who is also a real estate broker, I'm going to say that it's going to be B, corporation sole.
Yeah, well, I'm sure there are some that are real estate.
I'm sure they are too. I'm just saying.
But the organization cannot be licensed as a real estate broker. It can't be registered as a real estate broker.
Got it.
Good. All right, let's look at 24. The formula to calculate the overall capitalization rate is A, NOI divided by value or price, B, NOI divided times value or price, C, debt service times value or price, or D, NOI divided by owner's equity.
Well, the answer is definitely not debt service times value. That's for sure. And I just remember this one because you gave me a little bit of a hard time on that one. NOI divided by value. Remember that I did not remember that, and you were like, "How come? This is what it is right here."
Well, you remember the little diagram, right?
Yeah, I remember the diagram. Yeah.
Right, R times V, right? I over
Yeah.
R times V, right? You cover the one you don't want, and it gives you the
It,
formula.
it gives you the formula. Yeah.
Right, so I equals NOI over the line is R times V.
R times V.
If you want to know I, right?
If you want to know I, then you cover the I. Well, actually, no. In this one, you would cover the R. You cover the R, and
Right.
you
want
gonna be left
I'm
off.
just using an example, right?
Yeah.
Of course.
Yeah.
You're covering the R. So what do you have? I over V.
I
right?
over V. Yeah.
Right.
Amen.
So you remember what that looks like, right?
Yes.
On the chart.
I have it in my brain.
Let me annotate it real quick. Hold on. So remember, you have I, for that question, you have I over R times V, right?
Amen.
So if you want to know NOI, you cover that and you got rate times value.
Amen.
Want to know rate, you go I divided by V, right?
Amen.
If you want to know value, you go I divided by R, right? You cover the V. So in this case, we want the rate. So you go net NOI divided by V. So it has to be A. It has to be that one, right?
Amen.
All right, man.
That's
Cool.
it. I like it.
Perfect. All right, let's look at 25. Which action is not a requirement under the Truth in Lending Act and RESPA? Integrated Disclosure Rule, TRID. A, give mortgage applicants the closing disclosure at least 3 business days before closing. B, require that the mortgage applicant receives the information booklet, your home loan toolkit within 3 business days of a loan app. C, give mortgage applications a list of competing lenders so they can comparison shop for the best rate. D, give mortgage applicants the loan estimate within 3 business days of receiving the loan application.
As I was doing that one, I did not know that. Well, I did not. I did not remember that TILA was Truth in Lending Act. I just now that
And
you
really,
said that.
RESPA is Real Estate Settlement and Procedures Act.
What is it?
Real Estate Settlement and Procedures Act.
Okay, the other part. Okay, great. Yeah, I honestly did that one out of like what made sense at the moment, and it was that they're not supposed to, or it's not a requirement for them to give mortgage applicants a list of competing lenders. That just sounds so much not like what a company would do. Like
That's not illegal. Well, it's the law. It's a federal law. And so that's not a legal thing. I mean, ethically, when you should give your client a couple different mortgage people to go to. You say, here's 2-3 people I work with. You know, this is a person that does my work, and then there's 2 more here that you can look at, right? Ethically, you should give them. You don't want to say, here, just use this one. You want to give them options, right? Because you're kind of pushing them to them if you say, hey, use this one.
Yeah.
You don't want to be, that could be violation. You can say something goes wrong or pushing people to somebody like that. You want to give options. Here's 3 home inspectors. Here's 3 insurance people. Here's 3, So
they're not required to do so.
I mean, it's good to give that ethically, but it's not a law, right? All the other things there are law. You have to.
Yeah.
Right? Process of elimination on that one, right?
Yep.
Okay, let's take a 10-minute break and we'll come back. We did the first 25. Each 25 will take a 10-minute break. So let's get a little break, get up, move around a little bit, and then we'll come back and we'll resume the review. Okay.
Sounds great. See you in a little.
Okay, welcome back from break number 1, and let's go to number 26. A transaction broker does not have which duty? A, duty of using skill, care, and diligence in the transaction. B, duty of accounting for all funds. C, duty to disclose all known facts that materially affect the value of residential real property and are not readily observable to the buyer. Or D, full fiduciary duties to both the buyer and the seller.
The answer for that one is going to be full fiduciary duties to both the buyer and the seller. That would be dual agency, and that is illegal in the state of Florida.
No. It won't be. No. It won't be dual. That'll be single agency, right? Full fiduciary. Well, to both buyers. Yeah, you're right. You're absolutely right. Yeah, because full fiduciary duties to both buyers, that you can do that, right? There's only one time, right? When it's a commercial deal, it's $1 million and over, and you're a designated agent, right? That's the only time.
Amen. And he has to be consenting.
And the buyer and seller agree to it. They request it, right?
Amen.
Good. So A, duty, that's add, right? That's in all of them. Accounting for all funds, right? That's in all of them. Disclosed, that's all of them. They're A, B, and C are in all 3 of them, right?
Yep.
No, and transaction. Yep. Good. 27. Which governmental entity must be informed when the FREC takes disciplinary action against a real estate licensee? A, Division of Firearms and Tobacco. B, Division of Florida Condominiums, Timeshares, and Mobile Homes. C, Florida Department of Administrative Law. D, County Courthouse where the licensee resides.
The answer is going to be B, because the Division of Florida Condominiums, Timeshares, and Mobile Homes is a different division from the residential and commercial.
And they have to be in communication, right?
Amen. They do have to be in communication, so that's why they should let each other know when any disciplinary actions are taken.
Good job, man.
Thank you.
28. A real estate brokerage company is a transaction broker for a buyer. The buyer wants to purchase a new home, so the sales associate takes him to 3 model centers listed by 3 competing real estate companies. The sales associate must give a written no brokerage relationship notice to A, the buyer, B, the model home employee at each model center, C, no one, the owner developer of each new home subdivision.
The answer is definitely not the owner developer of each new home subdivision. That would be crazy. So the answer in this case is going to be C. to nobody.
Nobody, right? It does not apply on new home sales,
There we go.
the builder. So that's kind of a tricky question. It kind of makes you, but yeah, it's no one. See, absolutely correct. Okay, so let's go to number 29. Title to real property is technically conveyed when the deed is A, recorded in the public records, B, voluntarily delivered and voluntarily accepted, C, signed in witnesses, or D, acknowledged.
So I put signed and witnessed, but that is wrong. So I'm gonna
It's wrong.
go with voluntarily delivered and voluntarily accepted.
Correct. It has to be accepted. It
There
can
you
be
go.
done, signed, everything, but if it's not accepted, it's not valid, right?
There you go.
Okay, and then that's what kind of notice when you sign, when you see it, witnesses, when you sign it and see it and it's handed, what kind of notice is that?
That is actual notice?
Right.
No.
And yeah,
Yeah.
you're actually seeing it.
Yeah,
And when it's recorded in the public records, what kind of notice is that?
constructive.
Very good.
Thank you.
Number 30. Which variable does not influence demand? A, availability of mortgage credit. B, availability of construction loans. C, income of consumers. D, consumers' taste and preferences.
So this one, I think they all influence demand a little bit, because the shortage on supply may not necessarily influence demand, but it will make everything more expensive essentially. But the answer for this one is going to be B, the availability of construction mortgage or construction loans,
Right.
because it doesn't directly influence it.
Well, let me explain to you. Availability of mortgage credit, it affects it because that's for a buyer to get a loan, right?
Yeah,
Income of the consumers. If it goes down, they can buy less, right?
yeah,
Consumers' taste and preferences. They don't like that style of home anymore.
there
That
you
can
go.
affect it.
Yeah,
Now, availability of construction loans, that affects supply, not demand.
yes,
That's for the builder to get the money to build them.
yes. But
So
that, but
that has nothing to do with the buy side. It has to do with the sell side,
yeah.
build side, right?
But just like you said, influence. I mean, demand and supply. They
Yeah.
they both go in different directions. Therefore, if there is less supply, then even with the same demand.
That just means the price goes up. It has nothing to do with
Yeah.
the, right?
Oh, okay, gotcha.
See, that's price. That's price. The demand is
Oh.
buyers wanting it, right?
Oh, okay, gotcha.
So mortgage credit, income, and tastes, right? Construction is that would be which one, influences supply, right? If they ask
Yeah.
which that question was which one influences supply, it'd be construction loans, right?
Yep, got it.
Good. So 31, a seller transfers title to a buyer with a general warranty deed. In which clause of the deed does the seller define the quality of the ownership interest conveyed to the buyer? A, covenant of further assurance. B, covenant of quiet enjoyment. C, habendum clause. And D, season clause.
This one was interesting. I'm not gonna lie to you. I got it right. But I'm gonna tell you the thought process that I went through for me to go to that one. So, covenant of further assurance.
Mhm.
I think, I don't know that.
No such thing as it.
Yeah, it doesn't sound like anything, to be honest. The covenant of quiet enjoyment, it pretty much means that the person who's buying the property is gonna be able to enjoy the property uninterrupted from other people claiming the title.
Right.
Man, I'm so good at this. I appreciate it. Thank
So
you.
it's not that one, right?
It's not that one. The Hobbinen, that one I was a little
Habendum.
abandoned. You see, I cannot even pronounce it right. That was a little bit questionable on, so I'm gonna leave it blank for now. But then the season, I think is how you call it.
Season clause.
Season clause. Season clause pretty much express that the person conveying the title has interest on that title or
The season clause simply says that they own it and they can sell it.
There you go. That's what I was trying to say. I was just trying to use some different words. I'm sorry. So addendum would be the one.
Right, and the addendum clause is the clause that explains the ownership, the type of ownership, the rights, what they have. That's the addendum clause. And they're asking what the quality of ownership is. So it has to be the addendum clause,
There you go.
right? Process of elimination, even if you didn't know it, like remember it, right? You know it's not the other three, so it has to be that one, right?
There we go. It has to be that one. Because that one I was kind of questionably on, like, because the name itself doesn't quite tell me anything.
Yeah.
That's what it is.
All right, let's go to number 32.
Let's go.
A single agent broker received an offer on a listed property at the seller's price and terms. Before informing the seller, the broker received a higher offer. The broker submitted only the first offer, and the seller his principal accepted it. The broker has done what? A, has violated his fiduciary duty to his principal. B, is guilty of conversion. C, has fulfilled his duty to the seller because the offer was for the seller's full price and terms. D, is not required to submit the second offer.
So since they are in a single agent brokerage relationship, the agent, the broker, I think it's a broker in this case. But yeah, the agent, so the broker, the person helping the licensee, should show all offers and counter offers. I think is what it is. Or percent, I think it's either percent or show, one of those. So the answer is A. They have violated his fiduciary duty to the principal.
Correct. He has the right to show. Remember, transaction broker and single agent both have that.
Yeah, there you go. There you go. That's what.
No brokers doesn't, right?
Yeah.
Good. 33. A man earned a $7,500 commission by selling a coin-operated laundry business, which has 6 more years before the expiration of its present lease. The man A must be registered with the Florida Retail Commission as a business broker. B must be registered with the Florida Real Estate Commission as a business broker. C must be registered with the Florida Real Estate Commission as a real estate licensee. Or D, need not be registered with any state agency in the given situation.
I put D, but I think it's C.
D would be a class 3 felony.
It would be. I don't know, because the way that I looked at it, it was like, okay, so I am renting a place in which I have a coin laundry machine.
When you're renting it, it has what kind? It has what? How do you rent it? What do you get?
I have a lease on it.
Right. And when you have a lease on a business, it's considered real property.
Yeah, yeah. So if I have a lease and I sublease, I can either sublease the lease,
or they can assume it,
or they can assume it, right? So if they assume the lease, and I make some profit out of it because I don't know, I'm charging them for this.
You're talking to landlord. You're selling the business. You're not talking about the landlord.
Well, I was more referring to the tenant. The tenant that
the business though.
What is it?
The tenant's selling the business.
Yeah, if the tenant is selling the business,
but the man earned a commission. A third party earned a commission for selling it.
Got you. I think
the tenant sold his own business. He wouldn't need a license.
Yeah, that's what I thought. But I think the word that I should have looked into was the commission part, because if it was a tenant selling his business, he wouldn't earn a commission. He wouldn't earn profit. Correct. If there was anything, it would be a profit.
See, when you read the question, that's how you have to know it.
Yeah.
Because it doesn't say it there. So a man earned, if a man earned 75,000 and that word commission wasn't there, he wouldn't need a license.
Yeah, because he would be
selling his own.
Yeah, his own business. Right. Yeah, that makes sense.
Right.
Makes sense.
But see, that's how it's tricky. Anytime somebody makes money on selling a business or real estate, residential, anything, and gets a commission, they must be licensed. And here's the thing: even if they don't get a commission, they still have to be licensed.
Yeah, because it's somebody else's.
Unless they're involved in the ownership of it.
Got it.
right?
Got it.
Got to remember that. Yep.
Yep. So the answer is C for this one, right?
Answer is C, right? Because A and B don't exist,
Yeah.
right?
Amen.
No such thing. And business broker, you have one license for that, right?
Yeah.
So A and B don't exist. D, if he owned it, great, but he doesn't, right? You got a commission. Okay.
Got it.
Let's go to 34.
34.
3 claimants are requesting relief from the real estate recovery fund. All 3 claimants were named in a single judgment, the same real estate transaction. Okay, so it was all one transaction. What is the maximum payment from the recovery fund for this claim?
On that one, I was about to put 150,000. I was going to.
Right.
But then I read the whole one single transaction.
Right. Exactly.
And then I realized that it's 50,000 per transaction and not by claimant.
Right.
Therefore, the answer is A, 50,000.
Now, if it wasn't one transaction, it could be up to 150, right?
Yeah, it could be up to 150.
But
so if there's
wasn't,
5,
because it was one transaction, it's 50.
Yeah.
Right.
Yeah.
Very good. That's very, very good. That's exactly what.
Appreciate it.
But 150 is the max, though, right?
Yeah, 150 is the max. So if there's like 5 transactions, they're still gonna get 150.
Yep. Okay, so let's look at number 35. Which federal law made bait and switch advertising a federal offense? A, RESPA, Real Estate Settlement Procedures Act. B, the Truth in Lending Act, TILA. C, Equal Credit Opportunity Act, ECOA. Or D, the Federal Reserve System.
So could you explain a little bit of what bait and switch is?
That's when you put in the ad, payment $199 a month. You get there. That's what $10,000 down. Really 234 because they didn't add tax in. Yeah, that's bait and switch.
Got it. Yeah. So the answer for this one is going to be Truth in Lending Act.
Right. Remember when they did that, it made it illegal. We talked about that in the slide.
Yeah, we did. You mentioned that in radios, they usually be like.
Yeah, at the end of the radio ad, they talk about all the fast things, or in the fine print, or on TV, they do the same thing, right?
Yeah.
That's because they're required to say that.
Yeah.
They should be required to say it at a certain speed too, so they don't.
Yeah, right. Yeah, because I don't know who they think is gonna. I'm gonna record them once and like put in slow motion so I can actually tell what they're saying.
So let's go to number 36. Very good. The C and D don't matter on that one. ECOA has nothing to do with it. Federal Reserve has nothing to do with it, right?
Yeah, definitely. I don't even think we talked about that one. Those people that much. The Federal Reserve.
Equal credit opportunity is when is for lending and everybody. Yeah. Everybody's equal, right? You can't discriminate, right?
Yeah.
The reserve is just the monetary. I mean, that's the reserve.
Makes sense.
Okay, so 36. Local government exercises its greatest effect on the real estate business by A, creating tax shelters for those developing low-income housing. B, using zoning, taxation, and planning and the planning process. C, providing financing where justified. D, supervising contractors and their on-the-job performance.
So local government exercises its greatest effect on real estate business by B, using zoning, taxation, and the planning process.
Yeah.
Isn't that through police power?
It's police power, yeah. Yep. Yes, it is. Now, A, creating tax shelters for those developing, that would be part of zoning and taxation.
It would be.
That would be like part of B. Like that is actually an example of it, but it's not saying what it's not just that. That A is an example of B of one of using that. C, they don't provide financing.
They don't.
D, they don't oversee the jobs. They just do the permitting and then they check and inspect it, right? Make sure it's done right. They don't care who's doing the work.
Yeah.
Right? Good. Okay, 37. Which information must be disclosed to all prospective buyers? A, the seller's brother was murdered in the residence. B, a previous occupant was infected with HIV. C, the home is situated in a floodplain area. Or D, the neighborhood residents are Hispanic.
Tacos. So this has to do with material facts, doesn't it?
Well, if you remember, there was a section that we went over where it has
Yeah.
to do with the home. The
Yeah,
home
that's
consists of material facts,
there you go. There you go. There you
not
go.
the occupants, right? The occupants do not have to be disclosed, right? Things that happen to the occupants do not have to be disclosed.
Yeah. So that's what I was saying. I chose the answer as C. The home is situated in a flood-prone area because that is the material fact that is related to the home itself and not to the homeowner.
Right. So A and B are the people, doesn't matter.
Yeah.
Okay. And then D is illegal. You can't do
Yeah.
that.
Yeah. That's Is that not what is it? Blocking? Something blocking.
That's steering.
Oh, steering. Yeah, steering. I thought steering was only when you were guiding people to go somewhere.
Well, if you're saying that neighborhood is one way, is one class or not one class, it's the same.
Oh, okay, got you. So either you're doing it to make it
or steering people away from it, right?
Okay, got you. Still
So by
steering.
doing that, that's technically you're saying this. That could be either steering them to or away, depending on who the people are, right?
Got it.
Blockbusting is saying, hey, sell this type of class is moving in. Get out of here.
Oh, I see.
Right. That's the difference. You got to know the difference of those. Yep.
I got it.
Okay, number 38. Which statement does not describe a planned unit development? A variety of types of housing may be used. B, dwelling units are typically clustered with planned green space areas between clusters. C, industrial parks are a welcome offshoot of the PUD concept. D, the open space areas are maintained by the community association.
So all of those are right, but C, industrial parks
Absolutely.
are a welcome offshoot.
Correct. Remember there's a green space between them?
Yeah.
Right? So all the other ones are right. You can have all different housing, single family, condos, right? Apartments. Dwellings are clustered and they have green spaces between. Yep. Parks and things. And open areas are maintained by the community association. That's true. Absolutely.
Makes sense. Let's go.
Okay, 39. A real estate broker is accused of taking money from the company escrow account to pay personal expenses. The broker decides that she does not want to go through the hearing process, so the broker turns over her real estate license to the DBPR. What term describes the situation? A, emergency suspension. B, voluntary relinquishment for permanent revocation. C, revocation, or D, suspension.
It's going to be B, voluntary relinquishment for permanent revocation. That's the only one that just makes sense.
That is absolutely it. Yep.
Yeah.
Let's go to 40. A licensee makes a statement that is material to the transaction as though it were a fact when the licensee does not know whether the statement is true or false. And the buyer relies on the statement. As a result, the statement made by the licensee, that the buyer suffers damages. This situation constitutes culpable negligence, B, fraud, C, breach of trust, or D, deceptive services.
On this one, at that point, I did not have it so clear. I just cleared it now in this conversation that we're having.
Yep, absolutely.
Yeah, and now that we're having this conversation, I just cleared it. So back then, I put A, culpable negligence.
Yep.
But in reality, I know now that the answer is B, fraud.
Right. You see, the way this works, reviewing this, I'm talking to you about it. I'm telling you how it can be, how it can't be, how things relate, how it could be the opposite. Now things are much clearer, right? You're starting to narrow it down. You can see questions different ways, but I'm showing you different concepts and ways of thinking about it. Yeah. So now you know the difference between fraud and culpable and negligence. You know that now. You're never going to forget.
Yep.
So let's look at 41. The DBPR may issue which penalty for an initial offense of a minor violation by a licensee? Notice of noncompliance, A. B, subpoena to appear. C, notice of assignment, or D, a final order.
This one I did not answer. Could you please?
Yeah. So the DBPR may issue which penalty for an initial offense of a minor violation by a licensee? Okay, let's look at, let's start with D, a final order. That's issued at the end, right? After a hearing, everything. So it can't be. Notice of assignment, I don't know what that is. Subpoena to appear. That's when you have a case and you're being subpoenaed to be a witness or subpoenaed to be heard, like to a case.
What does it mean, subpoena?
That's what the court issues. A lawyer issues subpoenas, and then you have to go to court.
Oh, okay, okay.
You
It's
have to
like
go
an
to a
order.
hearing. Yeah, it's an order, and you don't show up, you're in contempt of court, right?
Okay.
You'd be arrested for that. Notice of non-compliance is when you have a minor violation. Like, for example, you moved, you didn't change your driver's license. They may send you a letter when they find out. Change your driver's license within 10 days, or you're going to get a fine. A notice of non-compliance, just say, hey, it's not compliant, fix it. Right?
Gotcha.
So the correct answer is a notice of non-compliance. If you don't fix it, the next thing is you get a citation. That's when you got to pay money.
Oh, amen.
Right? So notice of non-compliance is the least. Okay.
Got it.
Okay, so number 42. A man owns a farm in fee simple. He deeds the farm to a friend until the friend dies, at which time a woman will acquire a fee simple title to the farm. The woman's interest in the farm is A, a life estate, B, a fee simple estate, C, a reversion estate, or D, a remainder estate.
Yeah. And this one, I had a little bit of a struggle in the part where he said, at which time a woman will acquire. Like, I was trying to make sense of it, and it took me a little bit, but then afterwards, I kind of realized what it was. So the woman's interest in the farm is a remainder state.
Absolutely right. Yep. Good.
Yes.
Now, the reason for that, let me explain to you. So a life estate is what the guy got. Friend, right? The friend got the life estate, he dies, that's it, right? He got it.
Yep.
Fee simple estate, it can't be that. I mean, she's getting a fee simple. It's telling you she's getting a fee simple estate. I mean, it's reversion would be if the property went back to the man who gave it to the friend. Right?
Yeah.
But because it's going to the woman, that's a remain. She's the remainder man. It's called the remainder man, remember?
Well, in this case, remainder woman, but yeah, you're right.
It's still be called remainder man. It's just that, you know.
I was wondering why you didn't say
Yeah.
remainder man. I was looking for it.
Yeah, it would still be.
Yeah.
They haven't got to that one yet.
Question for you when it comes to that, and I'm about to make some topics up here. So going back to the life state situations, right? So life state, no, not that. Homestead. So if a guy registered his home as his homestead and he's married to his wife, and then he dies, the wives is going to stay in the home. If they do not have kids, then she's going to have a fee simple state to the home.
But it would be fee. I guess it would still be fee simple, but it would be a life estate for her, and then she would determine who it goes to after.
Oh, okay, got you. But like it's a fee simple concept because she will decide what happens with the house afterwards. I guess,
Yeah. Oh,
right?
yeah. That would stay the same as if it was just him. That don't change.
Oh, okay, got you. But then
The bundle of rights won't change.
But then if they have kids, then she will have a life estate title.
It would be inherited to the kids.
And they'll be inherited to the kids, and they will be the remainder.
Remain. Yeah.
Got it.
Correct.
Appreciate it.
Yep. Okay, number 43. Business brokers appraise businesses using appraisal methods similar to real estate appraisals, except A, stock, bond, and debenture analysis, B, asset appreciation analysis, C, working capital analysis, or D, liquidation analysis.
This one I know the answer to, but I do not know why. I didn't answer it myself. Could you please?
Yeah. Well, stock, bond, and debenture, you need to know how to analyze those, right? If there's a public company with stock, you need to value that. So that's correct. You need that. B, asset appreciation. You know, if assets are appreciating, you need to know that as well to do an appraisal. Working capital analysis. That's what's in there for the working capital. You need to know that for an appraisal for a business. Liquidation analysis. That's only used when a business is going out of business or filing bankruptcy. So which one do they not use when doing an appraisal?
I mean, it says here that it's liquidation analysis.
Right, because
Um,
you're appraising a property for value to sell it. The only
Oh,
time
okay.
you use liquidation is when you're going into bankruptcy or foreclosure.
Got it. So
It's not saying that if they said business is going out of business, which one would you use? It'd be liquidation.
Got it. And would that be
Because
done
you're
by a
appraising
business
it.
broker?
Say it again.
Would that be can that be done by a business broker?
As long as it's not a federally related mortgage getting it.
Oh, okay.
Yeah. Don't look too deep into it. They're saying the business broker appraises it, right? So if they're saying that, you assume it's not. It's okay. You assume it's okay for that.
Yeah, because
They're
it's
telling
already
you that's what's
sold, I
happening.
guess.
Yeah, that's already happening, right? So
Okay.
in that case. All right, so let's look at 44. What authority originates from the U.S. Constitution and relates to protection of health and welfare of citizens at local levels? A is cheat. B, I always say citis. C, police power, or D, community protection power.
So is cheat is the process that is done when somebody dies intestate, I think is what it is.
Oh, no, not intestate. It's when someone dies with no heirs.
Oh, with no heirs.
And
That's what it
the
is.
state takes the property.
That's what it is. So the
And the way you
state
can
is
remember that is it's cheating. The state cheats you
yeah,
out of
yeah. I mean, they do it all the time, so might as well.
So if
I
somebody
got you.
dies and they
Yeah,
have
I
no
thought it-
people, right? Nobody left, and they don't give it in a will to somebody, the state's just going to take it and do what they want with it.
And that's an cheat. Okay. Citus? I don't know what that is. So the answer for this one is going to be police power.
Yeah, because community protection power doesn't mean anything, right? Like
Yeah.
that's just made up, right?
Yeah, and B is also made up, isn't it?
Which one?
Citus?
Well, no, citus is the purpose of a legal jurisdiction or taxation and what it belongs to.
Oh.
So it's where something exists or originates. So that would be like with the taxation or with the property tax office. It's where it exists. It's basically saying this originates here.
Okay.
So there's a technical term for it, but it doesn't relate here to this.
Got it.
Okay. So yeah, it's police power.
Police power.
That's how they do it. That's how they regulate it, right?
Yep.
Okay, good. Let's go to 45. Which element is not essential in a valid real estate contract, sales contract? A, a legal objective or purchase. B, competent parties. C, an earnest money deposit. D, the vendor's signature.
That one I honestly thought I had it right. I chose A, and I really I was very confident about that.
Yeah, no, you gotta have a legality, you gotta have a legal objective to buy the property, right?
Wait, so
it's a little tricky.
Isn't a legal objective just like a reason?
Yeah, you have a purpose. It's a purpose.
I didn't.
Contract there's a purpose for the contract. It's to convey a property, right?
I understand, but what is do they have to specify why they want to convey the property?
No, it just says what they're doing. You don't got to say why. You just name.
Oh, I see. Okay. You see, that makes more sense. Like I thought it was like, oh, I want to sell it because I don't like the property anymore, whatever. Like I thought that's what it was saying.
That could be. That could be an objective. That could be.
Oh, okay. But do they have to disclose all that, or do they? That's optional. Okay.
Oh, it just has to. Somebody has to want to sell it. Somebody has to want to buy it. That's it.
Got it. But isn't it the case that both parties do not have to be competent?
No, no, they both have to. No, that's a deed.
Oh.
That's when somebody's signing a deed over to somebody. The person receiving it does not have to be competent. The deed person signing it and giving it has to be.
I feel like
That's the deed. Remember, they just have to receive the deed. They can be drunk and they can get the deed and have it. Because they're not, it's the person giving it has to be competent on a deed. Just a deed. On a contract, you both got to be competent. So if somebody's selling you a property and they're drunk and they sign it and then they wake up in the morning and say, I don't want to do that. That don't work,
Got it.
right?
So I feel like I should have known this a long time ago, but I'm just gonna confirm it now because it just clicked in my head. So a sales contract is a document. Let's say it's a document that is signed by both competent parties from the buyer and the seller, right? And then a deed is just a document that is signed to transfer the title of or ownership or interest of a property, but it doesn't imply that anybody's going to be paid for it. It's just being transferred.
Well, no, in the deed, there's a value in the deed. The value goes in the deed. It's part of the deed. It's part of the layout of the deed. There is a amount of money in there, sure.
Okay.
It has to be. It's required.
So if I am giving my property to a friend, for example, we're gonna use a deed.
Yeah, you don't need a sales contract. You just go give it to them.
Yeah. So I'm just gonna So, but I can also use a deed with an exchange of a property for money, I guess, without a sales contract.
In a sale, sure.
Okay, is that without a sales contract, or would that include a sales?
Oh, you would need a sales contract for that.
Oh, okay. So the sales contract is gonna have both our signatures and all that stuff, right?
It's gonna have all the details. It's gonna have
all the details. But then in the deed, it will also establish the amount that we've already put in the contract.
All that stuff. Yeah. Well, yeah. Everything will be on the deed. Sure.
Okay. Got you. Yeah, it just now clicking. Like I don't know. All right, keep going.
Deed is what transfers ownership.
Transfers ownership, and then the contract expresses how that ownership is.
The contract is an agreement to sell the property.
To sell the property.
Okay. And then they do all the research. They check it. They want to buy it. Boom. You go to your closing date. The closing is when you sign the deed. You sign your mortgage. All that's done there, right? Okay. The contract is just the agreement to sell the property.
Okay, got it. So that pretty much means that the deed can be used for a lot of other purposes, including selling.
Deed is used for one thing: transfer property.
Transfer property. Okay, so whenever the property is being transferred, the deed must be okay. Got it.
The deed is what conveys the property. You can't give a property from one to another without a deed.
Yeah.
Okay. It's like buying a car without a title. It's like buying a car without a title. You're gonna buy a car and get no title and go, how you can't drive it, can't register, it can't do anything, right?
Not yours.
I'm trying to use like similar terms to give you an idea.
Yeah, I appreciate it. So yeah, in this one I still do not know, because I think, and for a valid real estate sales contract, there has to be a consideration. Therefore,
but the consideration is in the contract. The physical deposit is just acting on it.
So would C be the answer then?
C is the answer. Yeah. Because listen, in the contract, you say, I'm going to give you $10,000 within 3 days of signing this contract. So the consideration is in there. You already said what you're going to do, and they're going to accept it, right?
Okay.
The actual act of putting the money in is not part of the contract. That's doing what the contract says.
You're just complying with okay.
Right?
All right.
So the contract says, I'm going to give you $5,000 deposit if you accept this. Everybody accepts it. Great. Now you go take the deposit. That's a separate action.
Gotcha. It's not necessarily included.
People sign a contract and never put the deposit and then cancel.
Oh.
So the deposit doesn't bind it. Now, if you don't put the deposit in, the contract's void, right?
Got it. Okay.
But that doesn't make the contract. The contract happens before the deposit.
Makes sense. Okay. The contract is valid before the deposit.
Right. Now, if you don't make your deposit on time, now it's not valid.
It's not enforceable at that point, I guess.
Right. Correct.
Okay. All right. Got it. Thank you.
Okay.
And then vendor's signature is just the seller's.
Yep.
The seller's signature. Okay.
Yep.
That has to always be there. Okay.
Yeah. Exactly. All right. 46. A provision in all mortgages that allows the delinquent mortgager to avoid foreclosure by paying all the back mortgage payments, late penalties, and cost of collection up until the time of foreclosure sale is A, equity of redemption, B, due on sale clause, C, acceleration clause, D, defeasance clause.
The answer, I think, is A, equity of redemption.
Yep, it is
But
correct.
I would like to know the difference between equity of redemption and acceleration clause.
Acceleration clause is the opposite. Okay, so remember when you don't pay your mortgage and they gonna go file the list pendants, they get the court judgment and then they use the acceleration clause. It makes all your payments due now. Remember all your mortgage payments for the next 30 years? They
Mhm.
come due today. And that's how they foreclose.
Oh,
Now, if you do your equity of redemption and go in and pay it and fix everything, they reverse the acceleration clause and it goes back to normal and you start paying again.
oh, okay. So acceleration clause is done by the mortgage companies to foreclosure your
Once they get the
place.
judgment, once the judgment
Yeah,
is given,
well, okay.
they do it. And the acceleration clause is what happens before they start the foreclosure. Like
Okay,
once it's the hearing and they give the judgment, the first step is the acceleration clause.
But that is done by both the judge and the mortgage company.
No, the mortgage company does that. The judge,
okay.
the order, and the mortgage company does the acceleration clause, not the
Okay.
judge.
But then on the equity of redemption, that's done by the consumer, by the
Yeah,
homeowner.
that's done prior to the sale, prior to the auction sale. If you go in there 1 minute late and they sold it, you can't get it back. It's done.
Got it. But even then, you would be the one that would do that.
Right. Well,
The
no.
home.
The equity redemptions mean you just walk in and you pay, and then no, the lender would say, okay, it's okay now. That's up to the lender to drop it. The foreclosure. You don't say I'm here. Foreclosure's dead. You go in, you pay everything, and then there's paperwork, and then the equity redemption says, look, they paid their bill. It's over now, right? It's no physical thing to do it. You just pay your bill.
Okay.
And then the mortgage company will update their files, right?
Got it.
Okay. Let's look at 47. The statute of limitations is the authority that outlines the A, requirement that real estate sales contract be in writing, B, essential elements of a contract, C, remedies available in case of breach, D, period of time during which a contract may be enforced.
The statute of limitation is the authority that outlines the period of time during which a contract may be enforced.
Absolutely correct. Yep. Statute of frauds is A. Essential elements of the contract, that's, I don't know, they just put that in there. Remedies available in case of breach, no, that's not.
But there is a part that talks about the remedies and what is done in case of
Yeah, but that's
disputes, I
just,
think is what it is.
yeah, there's remedies. I mean, it tells you what you can do. You can sue people, you can go to arbitration, you go to mediation, right? There's all different remedies, but it has nothing to do with limitations.
And how do you call? And I understand it has nothing to do with this question itself, but I still want to know what the statute, the statute's name is for that part that talks about the remedies done when there's a dispute.
No, there's no statute for that. There's nothing that says that. In your contract, you have remedies.
Oh, okay.
Solution. So you can either go to mediation, arbitration, or you can go to court.
Oh, okay. So there's not a part of the contract that's named.
No remedies. No, it's just the remedies are options you have if breach of contract. That's just saying if somebody breaks the contract, here's your options, right?
Okay. And where would you put those in the contract?
That's in the contract. It's already in there. The contract.
In what part?
It's a 13-page contract. There's a section in there for breach of contract, and it says if it goes through breach of contract, and if anybody breaches the contract, it lays out what your options are in the contract.
Okay.
Liquidated damages. Buyer breaks the contract. Their contingencies are over. They lose their deposit. It's in the contract. Right? It's all in there.
Is it like is it being specified like all over the contract, or is it like an actual section?
There's one section in the contract for breach of contract, and it explains.
Okay, gotcha.
Yep.
All right.
Don't worry yourself too much on that right now, because for the test, focus on the test, pass the test. When you start doing business, I mean, that's part of the training on the contracts, right? I mean, that's when you get to that point. Don't overwhelm yourself. Focus on what laser in on this. Then
Got it.
get the first step, and then that's second, right?
Yeah, yeah.
Cool. Okay, 48. When the parties to a contract state the terms of the contract and show their intention in words, either orally, in writing, or in writing, what type of contract classification has been created? A, parole, B, implied, C, express, or D, executed?
Okay. So the way that I went about that one is, for one, I don't really know what parole is, so I put that one aside. Implied is the opposite of what the question is asking. Is when things are not said in the contract. However, they are implied, and therefore, someone may be held accountable even if they do not do those things that are obviously implied, like if you steal or whatever. Executed means that the contract actions were already done, therefore they were executed. So in this case, the answer would be express.
Correct. The answer is express. Okay, so A is verbal only. That's
Oh, that's what that is.
implied is they look at the house, there's a washer and dryer in it. It's connected. They imply that washer and dryer is included in the sale, unless it says it's not, right?
Got it.
Okay. Express is exactly what the definition is here, right? Orally or in writing, right? And execute is when something's executed, signed, and it's agreed to. So express. But parole is verbal only. Yep.
Verbal only. That's what I did not know.
Yep.
I got it now.
Okay, got it now, right?
Got it now.
Amen. 49. Which item is entered on the closing disclosure as a credit to the seller and as a debit to the buyer? A, prorated property taxes that have not been paid before closing. B, seller's mortgage paid off at closing. C, prepaid rent on rental property. D, purchase price.
So in this one, the way that I went about it took a little bit of thinking. So prorated property taxes, they could, if it wasn't because they have not been paid. If they were already paid, then yes, yeah, we can give it back to the seller. But if they have not been paid, then why would we? Like, that's just crazy.
Right.
Seller's mortgage.
Right, you live first, and then you pay taxes at the end of next year for last year, right?
Yeah, it's just yeah, that's just not what it is in this case. Seller's mortgage, mortgage paid off at closing? No.
That would be a debit to the seller only.
Yeah, it would only be a debit to the seller.
Has nothing to do with the buyer, right?
Yeah, nothing to do with the buyer at all. And then we have prepaid rent on rental property. That is a credit to the buyer as opposed to a credit to the seller. Therefore, the only credit to the seller is the property price. I mean, the price of the property.
That's absolutely correct, because the seller is getting the money and the buyer is paying it, right?
Amen. Yeah, there's nothing else to do there.
Yep. Good. That logically think it out. That's what you did.
Amen.
Okay, which statement concerning tenancy by the entireties is false? A, it is a form of concurrent ownership. B, the estate includes right of survivorship. C, the property must be owned by a married couple. D, the deed must specifically state the intent to create such a tenancy.
On this one, I put A, but it's wrong.
Right.
So now, just say as a second chance.
Well, which one is false is the question.
Which one is which one is false? That's I'm trying to find out. I think it's the deed most specifically state intent.
Correct.
To create such a tenancy.
It's D, because think about this. A, it's a form of concurrent ownership. That means more than one person owns it, right?
Oh, that's what I meant. Okay.
Now, you have to be married for this one.
Yeah.
So if it's married, you have to be two people, right?
Yeah.
I don't think you can marry yourself yet.
Unfortunately.
I don't know. Maybe next year. I don't know. But anyway, so that's true. The
Yeah.
estate includes right of survivorship. One spouse
course.
dies, it goes to the other, right? It includes that. The property must be owned by a married couple. That's true, right?
Yep.
Okay. The deed must specifically state intent to create such tenancy. That's not true,
That's not true. Yeah.
right? Good. All right. Let's take another 10-minute break and we'll come back and we'll start on number 51.
Sounds lovely.
Okay, now we're going to continue with question number 51. The financial term applied to the use of borrowed funds to finance the purchase of an office building is A, leverage, B, liquidity, C, intermediation, or D, disintermediation.
Oh, I do not know what this intermediation would be. I don't think we talked about that. But I do know that leverage is using somebody else's funds to create wealth or to create an opportunity. So that's, yeah, I've heard that one way too often. So that's what that is right there.
You got it right. Liquidity is the money that you have available. And intermediation, I don't know. I mean, I don't know if that's conversation.
The fact that you don't know.
I don't
like it.
52. A mortgage in which changes in the interest rate may cause changes in the monthly payment amount is called a partially amortized mortgage, an adjustable rate mortgage, a graduated payment mortgage, or an escalator mortgage.
So for this one, I know the answer is B, but I don't have like a solid knowledge of that. So if you can,
yeah. A mortgage in which changes in the interest rate may cause changes in the payment, right? So if you have a fixed rate mortgage, it's the same payment all the way through, right?
Yeah.
If it's partially amortized, that means you're paying the mortgage and then there's going to be a balloon payment, right? Or a payment at the end.
What does amortized mean? Like, what does that mean?
Amortized means amortized over the years. A mortgage, it's the interest and principal payments. It's amortized. Remember the calculator I showed you? And it showed how much interest. That's amortization. That's why you pay back 300,000 when you borrow 100, right?
Okay.
Amortization. So that's the payment breakdown of the mortgage. A fully amortized mortgage is a 30-year mortgage. A partially amortized mortgage is a 30-year mortgage. You make payments for 15 years, but a lump sum is due at the end of the 15th year. Okay.
Oh, okay.
An adjustable rate mortgage means you're fixed for a term and then it adjusts in those periods, right? 2-year, 3-year, 5-year, 7-year arms. So if you have a 3-year fixed, 3-year adjustable rate mortgage, it's going to change every 3 years.
But that is stated in the contract. Like
yeah, of course. It's a mortgage type of mortgage.
Yeah, it's a type of mortgage. Okay.
A graduated payment mortgage is the first 2 years you pay this, the second 2 years you pay this, the third 2 years you pay this. Your payments go up gradually. An escalator mortgage, it's a term, but I never really, there's no technical. So an adjustable rate mortgage can affect your rate change and your monthly payment. So it's B, an adjustable rate mortgage.
Adjustable rate mortgage. Could you give me an example of that? Okay, I buy a house with the mortgage of 200.
Yeah, right now rates are 8%. You get a 30-year mortgage, 8%. You get an adjustable rate mortgage, they might charge you 6%. But remember, you have the index and the margin. So you get an adjustable rate mortgage for 3 years. It'll be 6% for 3 years. At the end of 3 years, it's going to adjust. It'll be the index, prime rate, plus whatever the margin is too. If prime rate goes to 9, your mortgage rate's going to 11 in 3 years.
Oh, okay.
Or if it goes down to 2, it goes to 4. So it can go up or down. It changes whatever those terms are in your mortgage. So it adjusts. It's not fixed for the whole time, just for that term.
Gotcha. So
then every 3 years it changes.
So I guess this mortgage is like a pertinent choice. Like it's a good choice if you're hoping or you can kind of see.
Let's say you're buying a house, you're only going to live there for 5 years.
Oh, okay.
7 years or 10 years, and you do that term.
Got it. Or if you think
you're buying a house to invest in, you're going to own it for 7 years. You know you're going to sell after 7 years, so you might do a 7-year adjustable mortgage, right?
Oh, so So can you choose how many years before you
So
adjust, or?
there's 2 year, 3 year, 5 year, 7. Yeah, there's different rates. If you look at
Oh,
the
there's
rate,
different, okay,
you
gotcha.
choose what you want and they tell you what it is. Yep.
Oh, nice, okay,
Different programs.
nice.
Okay, let's look at 53. Depreciation, that's cost recovery. Okay, A, it may be taken on a principal residence. B, it includes the cost of the land and the amount to be depreciated. C, is an allowable deduction on investment property that requires no current outlay of cash. D, does not include the mortgage portion of an apartment building and the amount to be depreciated.
All right, this one I got wrong. So let me see. Depreciation, cost recovery. So it's not A because that's what I chose and that's wrong. So that's
Right, so
maybe
right, let's go over it. So depreciation. A is maybe taken on a principal residence. No, it cannot be taken on a principal residence
Why?
because it's only investment property.
Oh, depreciation is only
Depreciation,
investment
remember
property.
27 and a half years, 39 years? Remember that?
Yes, yes.
Only investment property
Oh, okay.
is an allowable deduction on an investment property that requires no current outlay of cash, or B, includes the cost of land in the amount to be depreciated. No, it does not. Remember, you have to take that out?
Yeah.
Right. C is allowable deduction on investment property that requires no current outlay of cash, right?
What does it mean by no current outlay of cash?
You're not putting any cash out to get the deduction. So basically, the answer is C. D, it does not include the mortgage portion of an apartment building in the amount to be depreciated. Mortgage has nothing to do with it. They're trying to confuse you about mortgage principal and interest. That has nothing to do with it.
Okay. Could you
So-
explain C a little further? Because could you give me an example in which
It's an allowable deduction on an investment property that requires no current outlay of cash. You buy a commercial building for $100,000. The land's worth $20,000. The building's it's worth there's $80,000 difference. You divide that 80,000 by 39 years, and you take that off your taxes every year for 39 years. There's no cash outlay to do that. You own the property.
Okay.
You're not putting cash out, right? It's a deduction you get.
All right.
Okay. And the cash outlay thing means you're putting cash out to do something.
Okay.
Okay. 54. Constructive notice is A, information learned by reading, seeing, or hearing. B, information advertised in a newspaper. C, provided by recording in the public records. D, notarizing a conveyance.
Okay. Okay. So the answer is C, provided by recording in the public records. But I have a question.
Yep.
So we know that A is actual notice. Would B be also actual notice? Well, it would be, yes. Yeah. Yeah. I don't know what I'm asking.
Well, no, actually, if A is not actual notice.
It's not?
No, because learning it and reading it has nothing to do with it. Reading it and hearing, you have to see it.
Oh. So BE is actual notice, but A is not because hearing and
Right. You got to be there. You got to witness it to be actual notice.
okay, it's not like I heard that somebody told me. Okay, gotcha.
Yeah.
And then notarizing of conveyance. What about that?
That's the notary. That's the notary who's doing a notarizing of the deed.
Oh, okay. And that is that neither?
Say it one more time.
Is that neither of them? Is that
Well, notarizing conveyance is just a notary stamping it and saying they actually witnessed it, and they're
Okay.
verifying that everybody was competent, it was accepted and received, no one was drunk, right? The witnesses are who they are. They identify everybody.
okay? So
That's just the process.
okay. So that's when a notice is going from actual to constructive. Like there's someone in the middle of that because you saw something.
Yeah, actually, A is a type of constructive notice because once you record it in the public records, that's the constructive notice. Then people see it, read it, and hear it. That's actually seeing it as constructive notice. Does that make sense?
You probably mean actual notice for that one.
No.
Constructive?
Actual notice is when you're at the closing and their witnesses there and they sign and they notarize it and they do it all right there. That's actual notice.
Okay.
When they go and record that at the courthouse, that's constructive notice. Right?
Got it.
Right? Now listen, when it's recorded at the courthouse and somebody goes online and they look online and they see it, they see the deed, they read it, they see it, and let's say they played a video and it talks about it, like, because they can't see it, they use the handicap thing and it talks about it. Now they're viewing the constructive notice. The reason it's put in the court, in the public records, the reason it's put in the public records is so the world could see it. So by hearing it, seeing it, reading it, that's people using constructive notice to see it, right? To get it. But the actual constructive notice is when it's recorded at the courthouse, not after, not before. When it's recorded at the courthouse, that's constructive notice to give the world notice to it.
Got you. But in this particular case, it doesn't quite specify where you're reading it, hearing it, or seeing
right. Exactly.
it.
They're trying to confuse you.
So yeah, in this case, you may just hear a neighbor say, "Oh yeah, somebody bought that property next to us."
Constructive notice, you can learn it by reading it, seeing it, and hearing it. You can learn that, but there's a better answer. It's when it's recorded in the courthouse, in the public record. There's a better answer than that there.
I hear you.
That makes sense? You gotta look at that. Look deeper at it, because they'll try to trick you with something like that.
Yeah, they're good at it.
Yeah. All right, let's look at 55. In a deed, the warranty of quiet enjoyment pertains to A, peace and tranquility on and around the property. B, peaceful possession undisturbed by others, claims of title. C, guaranteed satisfaction with the property. D, property that is completely vacated.
I'm sure a lot of people chose the A one for this one, but it's B.
Yeah.
Yeah, we talked about this a little bit ago. That's the peaceful possession of a property undisturbed by others.
Undisturbed. 100%.
Yeah.
100%.
Yeah.
56. The original law requiring that an annual percentage rate be disclosed to consumers was the A, Real Estate Settlement Procedure Act, B, Equal Credit Opportunity Act, C, Truth in Lending Act, D, Florida Little FTC Act. Sorry.
It's D. It's D. You know it. Yeah. So this one I did not answer, but after seeing the answer, it just made sense. It just made sense. I didn't answer because I was not so sure when I was doing it. But yeah, it will be the Truth in Lending Act.
Absolutely.
It's
on credit cards, it's on credit cards, loans, like car loans, any other loans, mortgages. Yep. It's always the APR, right? APR. Remember when you figure out the APR, the yield 0.125 each, right? Remember all that? Yield, and then you add it together to get the effective yield.
Well, what does APR means again?
Annual percentage rate.
Annual percentage rate. That's
right. Remember you add it in to do the calculation. Yeah. Yep. Good.
Remember all that good stuff. I'm ready to do those math.
Let's look at 57. Eligible homestead owners may transfer up to what amount of their SOH benefit from their previous homestead to a new homestead?
The only reason why I remember this one is because you gave me an example of somebody that had a property of I think it was like 500,000, and then they had bought another property that was like 380, and there was like a 120 difference in there. And
it wasn't about buying it. It was the assessed value against the actual value. Right?
That's what it was. Yeah. But I know that the difference was 120,000. And you said that amount could be transferred to the new property, so they can,
But there's a maximum amount of it.
Yeah, and Yeah. But by remembering that, I knew that it was not 50, and I knew that it was not 100.
Right.
And 225 just doesn't sound right. So that's
Yep.
why I chose 500.
$500,000. Yep, that's right. It's $500,000.
Yeah.
Right. If it's a $3 million house and the appraised value is $2 million, they can only take 500 of that million. They can't use the whole thing, right?
Yeah.
That's the same
Does
concept.
that change if it's a married couple?
No. Nope.
There's something
The only
that
thing that
changes.
changes, the only thing that changes for a married couple is capital gains.
Mm.
You have a primary residence, you're allowed to sell it if you're single, and 250,000 profit is not capital gains. Anything over is. If you're married, you can make 500. Anything over is. That's the only thing that changes.
There you go. I knew there was something. Capital gains. Okay.
And only on the house you live in. If you sell an investment property, you make $1. Capital gains is on that $1 all the way up.
Amen.
Unless you do 1031 exchange, or unless you refinance. You refinance the property, take all the equity out, then sell it. You don't pay taxes on the equity. So if you buy a house, $100,000, it goes to 500,000. You do a remortgage, take out 450, sell it for 500. You only pay tax on $50,000.
Got it.
Okay. And if that's also your home, you would take all that money out and you wouldn't pay any tax, right?
Yeah, because you're gonna buy another house, I guess.
Well, no, you get 250 if you're single. If you're married, 500, right?
Oh yeah, you're right.
Number 58, which survey term is associated with meets and bounds description? A, range, B, township, C, point of beginning, or D, section?
So 3 of these are related to the government survey, I think is what it's called. And those are range, township, and section.
Yeah.
Therefore, point of beginning, which is I think those are by monuments. Is that what that is? I think it's monuments.
Monuments, right?
Man,
remember, meets and bounds is the oldest form of measurement, right? So think of point of beginning. It began there. Yeah. Point of beginning.
Yeah. It began there.
What do they give people? Statues. What are they called? Monuments, right?
Monuments.
For history. So it's the oldest monuments, point of beginning, right?
There you go. That is what that is.
59. A buyer who obtains a mortgage loan that covers the purchase of a condominium plus furniture, appliances, and other personal property, such as towels and kitchen utensils, has a blanket mortgage, B, chattel mortgage, C, wraparound mortgage, D, package mortgage on investment property.
Could you give me a nice explanation on this one? Because
okay, so blanket mortgage is when you have a mortgage that envelops more than one property.
Oh, okay.
Okay. Chattel mortgage, I don't know what that is. It's personal property. There's not really a personal property mortgage, right? I don't know.
You know what? That's a very good point. I totally forgot that chattel meant personal property.
Yeah. So wraparound mortgage is when you have a mortgage on a property and you're buying another property and you're going through a process, and like you say you're doing a construction loan and you have an interest-only loan on the construction and you're going to close it. Now the house is built and you have to pay that loan off and close it up onto a normal loan. That's the wraparound mortgage. It pays off the construction loan, seals it all up, and turns into a 30-year mortgage. That's like a wraparound.
Okay. So that is the type of mortgage that is used to just wrap everything up and just have one mortgage?
Correct.
Okay, got it.
A package mortgage on investment property. That's the answer. That's a package mortgage is a mortgage that includes personal property and the property. And it's on investment properties only. And condos is really the only place you're going to find them. It's all included.
Okay.
So package mortgage.
Good to know.
Okay. 60. The bundle of legal rights associated with real property ownership that does not include the right of A, control, B, intent, C, possession, D, disposition.
That comes from deep sea,
Mm-hmm.
in which the C stands for control,
Mm-hmm.
the P stands for possession,
Mm-hmm.
the D stands for disposition. You have the right to dispose it. There's not an I in there. Therefore, intent will
Yeah,
be.
the intent of what you want to do doesn't matter, right? I mean, that's
Yeah.
has nothing to do with it.
Yeah, it does not. However, I do not remember the E's, what they stand for. Could you remind me on that?
I don't know if okay, so you have
I can look it up. I'm sure I have it.
yeah,
written
no,
down
no,
somewhere.
disposition, enjoyment, right? Enjoyment.
Enjoyment, okay.
I'm trying to think of the other one. Disposition, enjoyment, possession.
Come on, Aiden. Come on, Aiden.
Disposition. Hold on. Disposition. I'm trying to think of it. I never do it in the E's. Disposition, enjoyment, right to enjoyment.
I find it before you say
Hold
it.
on.
I'm gonna be so happy.
Possession, disposition.
You can destroy it if you want to.
Oh, there you go. Exclusion.
That's exclusion. You can exclude people.
You have the right to trespass.
Exclude people. That's the right to privacy. Right? Exclude people.
That's what it is.
Enjoyment.
Yeah. And to
What was the
prevent
other?
trespass.
Was the other one enjoyment? Was it enjoyment?
Yeah, it was enjoyment.
Enjoyment,
Yeah.
I was thinking exclusion. I was thinking privacy, but I'm thinking that possessions there. You can't do privacy. I was thinking privacy, but it's actually exclusion. Yeah.
It's exclusion. And then enjoyment is the right to use quietly.
Yeah, and without disturb from others. Yep.
There you go. Amen. You know it.
Yeah, in and out. 61. Which state includes the right of survivorship? Or I'm sorry, which estate includes the right of survivorship? A, joint tenancy. B, fee simple estate. C, tenancy in common. D, tenancy for years.
It's going to be joint of tenancy. The joint tenancy.
Yeah, it's A. Right, because fee simple has nothing to do with that, right?
Not at all.
Tenancy in common is when they own it, but each person owns their share. They can sell it. They can give it to theirs, do what they want.
And they have different deeds, right?
What's that?
They have different deeds.
Yep, and tenancy for years has nothing to do with it. So
yeah, but I do want to make sure that you heard me. In tenancy in common, they have different deeds.
No, it's one deed. It's one deed.
It's one deed. So how would they change how would they transfer or sell their ownership or
it would be they would sell their ownership portion of it to somebody else, and that would be updated. It wouldn't be separate deeds. It'd be one deed for everything.
Isn't one of those tenancies that has different deeds?
No.
Huh.
The only ones that have different deeds is timeshares. That's 52 of them.
Okay, got you. And
remember timeshares per week? Remember we talked about that?
Yeah, 52 weeks.
It'd be like 52 fee simple deeds, right?
But they I don't know. It's okay.
That's what you were confusing that. That's what you were talking about.
Yeah. Okay, so in the tenancy in common, do they all have to sign the deed at the same time?
Yes.
Or can they join later? Okay, yes.
Oh, no, I'm sorry. Hold on. Joint tenancy, yes. Tenancy in common, no. People can come and go as they want.
Yeah, because they can transfer it. Therefore, yeah, that makes a lot more sense. Okay, so tenancy in common.
Tenancy. Yeah.
No, it's okay. So tenancy in common, they have something in common, and it's the fact that they own that property. Yeah. They own a portion of that property. And they can sell it or pass it to whoever.
It doesn't have to be equal either, right? It can be 50%, 25. Joint tenancy has to be equal.
It has to be equal, and there's only one deed that has to be signed at the same time by both parties.
Joint tenancy is one deed when you obtain the property.
Got it. Okay. So like brothers, I guess.
Family, yeah. Husband and wives do that too. Brothers, business partner. I mean, it just depends. It depends on the situation,
I hear you. Okay. Good.
So
let's go.
All right. 62. A title theory state is one in which a mortgage A transfers title to the lender or escrow agent until the loan is paid. C creates an encumbrance on the title to a property. Or B, that was B. C creates a tenancy in common until the loan is paid. D creates a joint tenancy for lender until the loan is paid.
Those are very interesting answers, but the answer is A.
Correct.
Transfer title to the lender.
Yep.
Or escrow.
Right.
So,
deed in trust. It's a deed in trust. Right.
Yeah, I have a question when it comes to that.
Mm-hmm.
So in these states that have that, I think maybe Georgia have it. I'm not so sure, but whatever state it is, that they have a title theory. Whenever you go into property appraiser, the name that is gonna be on that deed is it gonna be the lenders?
Well, it'll be a deed in trust. So it'll be the lender or whoever's holding it in trust.
So the name of the owner is not gonna be in there in the
No,
property appraiser.
Well, there'll be a deed of trust, and there'll be an encumbrance saying who the owner is. It's not going to say it on the deed until they pay it off.
And what is an encumbrance?
Encumbrance is a lien or something on the deed attached to it.
Okay.
So deed restrictions, anything like that is an encumbrance. A loan, a lien for a mortgage is an encumbrance. Anything placed on the deed is an encumbrance. Right?
Okay. Gotcha. So how do those people prove ownership of their property? Whenever they go to like banks and stuff like that, they show the deed, I guess.
Well, they would show the deed of trust. They would get a copy. They would have a copy of it. It would show that they're on the property. They're on the tax. They're on the taxes. They're on all that. It's just the way it's held. Just like when you own a car and you have a payment on it, right?
Okay.
Same thing. The bank holds the title. You don't get it till you pay it, right?
Yeah. Got it. Okay. Let's keep it going.
All right. Let's look at 63. Which terms refers to a situation where during the early years of a loan, the principal balance increases? A, graduated payments, B, positive leverage, C, negative amortization, or D, reverse annuity?
I know what the answer is, but I want you to break it down a little bit so I can understand it.
Yeah. Any time that your loan increases, your principal balance is negative amortization. That can happen on adjustable rate loans, right? So if you get a 6% rate, and let's say the rate goes to 8, so let's say the rate goes to 10, and your payment's only allowed to go 2% per adjustment. If you pay that payment, the difference between 8 and 10% will go negative on your principal. So every time you make a payment, your principal will go up because you're not covering the interest. That's what they're talking about there. Anytime your principal balance goes up, like a credit card, if you have $1,000 payment on your credit card, the minimum payments, or the payment's $20 a month. Let's say the interest is $35 a month. Your balance will go up every month, even though you're paying the 20, right? Same concept. That's negative amortization on the credit card, right? Same concept. Graduated payments has nothing to do with this. Positive leverage, no such thing. I mean, I guess there's positive leverage when you have a low mortgage amount. Reverse annuity, never heard of that. Negative amortization is any time your principal balance goes backwards as you're making payments.
And would that be because the
rates increased and there's a limit to what you could? That's going to happen to people with adjustable rates right now. They're going to tell you your minimum payment's this, but you can pay extra if you want. So just because your payment's whatever and you're going to go negative, you don't have to go negative. You can send the extra money, right? But they can't require you to.
Gotcha. Yeah, that's dangerous.
Okay. Well, that's what happened in 08, man.
Yeah, that's dangerous.
That's what happened.
Yeah.
Okay, so 64. Which statement is true regarding the monthly payments on a 30-year fully amortized loan? A, initially interest is the smallest portion of the payment. B, initially principal and interest are approximately equal. C, initially interest is larger portion of the payment. D, level monthly payment means the same amount of each principal paid each month.
The answer is C.
Absolutely. Remember I showed you the chart when we did the calculation?
Yeah, that is why I remember it, my good sir.
Yeah.
That is indeed why I remember it. 65, I would want you to break it down as you can. I'm going to take some notes as you do that.
Okay, number 65. Which secondary market participant is a guarantor of government insured and government guaranteed loans? A, HUD, A, Freddie Mac, A, Fannie Mae, and or D, Ginnie Mae. Which one is a guarantor?
Which one is a guarantor?
Yep.
I think there's three of them that are guarantor, I think.
Oh, only one.
Only one?
Yeah.
I
One
guess
of
that'll
them.
be Ginnie Mae.
It is. Yep. Ginnie Mae. And HUD is the department, right? That has nothing to do with this. HUD's a department, not an agency. Or HUD's an agency, not a participant. Freddie Mac and Fannie Mae, remember they're like brother and sister, and then Ginnie Mae's the cousin.
Yeah.
Cousin's the one that does something different. It's the guarantor of them. The full faith and credit of the United States government guarantees the loans, right? So it's Ginnie Mae. Good.
Okay, so Ginnie Mae is a guarantor.
He's a guarantor, yeah.
For the government, you said?
It's backed, yeah, it's backed by the full faith and credit of the United States government.
Let's see here. Okay, and then and then Freddie Mac and Fannie Mae, those are the sister,
That's like the brother. That's like the brother and sister. They're the ones who package them, sell them on the secondary markets, all that, right?
Okay. Do they specialize in different areas?
Yep. Fannie does residential, VA and FHA. Freddie does more of the commercial, VA and FHA.
Okay, so Fannie residential, VA, and FHA, and then Freddie
More
is gonna be
commercial, VA,
commercial.
FHA, and Ginnie Mae guarantees them all.
Oh. Okay. Thank you.
Good.
Yep. Got it.
Good. All right. Now let's go to 66. How much personal money may a broker place in a property management escrow account?
Is it $5,000?
$5,000, right?
Yes.
And
It
how
is,
much can
however, what
How
is
much
it?
can they keep in the other one for the sales?
1,000.
Perfect. Good. Right. Good. That's perfect, man. Good job.
Thank you.
All right. So 67. An example of an ad valorem tax is A, a special assessment, B, a property tax, C, an income tax, D, a zoning tax. An example of an ad valorem tax.
Could you explain a little bit of what an ad valorem tax? I didn't answer that one.
An ad valorem tax is basically a property tax. So what does that tell you?
That is a property tax. I mean, you just said it.
Yeah.
Yeah. So are they like synonyms or something like that?
Yeah. Income taxes on income, zoning tax, there's no such thing. A special assessment that's like when they do the road. Remember, you're paving the road and you split it between the two owners. That's a special assessment.
Okay.
So it's just a property tax is what it is.
Got it. Thank you.
Yep. 68. Which individual is exempt from the continuing education requirement? A, an out-of-state Florida licensee. B, real estate licensee who earned a 4-year degree or higher in real estate. C, real estate licensee who is a Florida licensed attorney. D, real estate licensee who holds a voluntary inactive license.
Answer is going to be C, which is real estate licensee who is also a real estate, well, he's also a Florida licensed attorney because, and only because, they're going to continue the education on the lawyer side of things.
Correct. Absolutely. That's exactly right. Yep.
Amen.
69. A developer who wants to develop a new subdivision must submit a subdivision plat map to the planning commission, B, a site plan to the zoning board of adjustment, C, an existing land use study to the planning commission, D, a thoroughfare study to the Department of Transportation.
Well, we definitely know that the answer is, the Department of Transportation, because that's, essentially, I'm just kidding. The answer is A, subdivision plat map to the planning commission.
Right, plat map, right? And they try to trick you with land study. It's a plat map has to be submitted and approved. Absolutely correct. Good.
Amen.
Number 70, you've been hired to appraise the local public library building. The approach that is likely to be the most relevant is the A, comparable sales approach, B, cost approach, C, public land and property approach, or D, income approach.
The answer is going to be, due to the fact that it's a library building, it's a public library building, there's no income for that thing, for one. They may have a little bit of income, but it's whatever.
There's rental income. There's no rental income.
Oh, well, there you go. There's also not other comparables like that one around that can be used. So yeah, it would be the cost approach.
Right, because there is no such thing as C, right? Public land.
Yeah. Oh, definitely not. I didn't even count that.
Good. Cost approach. Absolutely.
Amen.
71. The owner of a hardware store has filed for bankruptcy and the real estate is up for sale. The money that the property will bring in at auction is best described as which type of value? A, going concern value, B, salvage value, C, liquidation value, or D, investment value.
Well, we know that bankruptcy is something that is primarily related to liquidation. So we're going to say liquidation on that one.
And remember, that's the only time you use liquidation value.
Amen.
Bankruptcy or foreclosure, right?
Amen. Amen. Amen.
Okay. 72. The purchase price of a business minus the value of the tangible assets of that business equals the tangible assets of the business.
In other words, referring to the reputation created.
This includes,
includes the reputation.
Real property, common stock, or goodwill.
Amen. The answer is goodwill.
Correct. Goodwill. Absolutely. Good.
Thank you, sir.
73. A sales associate receives a $5,000 earnest money deposit from a buyer. She immediately delivered the deposit to her broker. The broker deposited the check on the third business day into his general operating account. This is the proper procedure for handling earnest money deposits. That was A. B. This is an example of commingling of escrow funds. C. The broker is guilty of dishonest dealing by trick, scheme, or device. D. This is the proper procedure, providing the broker uses the title company that has trust power.
I put as the answer, I put C. But is wrong.
Well, you can't be guilty of this. I mean, that's not. There's not a law.
I mean, I don't know what commingling means. And it just sounds...
Commingling means mixing the funds from the business and personal.
Then that's what it is.
Yep.
That's what it is then. Yeah. Okay. You see, I have noticed that the ones that I got wrong, it's usually because I just don't know a word.
Yeah. Well, that's why I've explained. That's why I was, the commingling. Yeah, that's what it is.
Yeah. Yeah. Like I have never heard that word in my life. And then the issuance thing threw me off as well in one of the last ones. That's why I wanted to look for it. But yeah, got it.
You've heard of mingling, just not commingling. Single and ready to mingle. You've heard of mingling before.
I have heard
mixing.
Of that.
There you go.
I have heard of that. You see, I appreciate you putting that in terms that I can understand. Single, ready to mingle. Let's go in.
Okay, so 74. Sales associate Terry Stauffer may have which information entered on his license, if applicable? Terry's Real Estate Services, Terry Stauffer LLC, Terry Stauffer Enterprises LLC, Best Homes Inc.
Amen. So we know that there's selected terminations for this, that they can be, like in your case, for example, I think you have, is it LP or AP?
I can't. I'm a broker.
Yeah, but in your signs, you
Oh,
use.
no, that's an LLC. That's no. This doesn't have to do with that. This has to do with if you're licensed, if you want to set up yourself as a corporation for tax purposes. Remember?
Oh, gotcha. Well, I went with the fact that it has to be something ending in LLC. That's what I went by. And then I kind of remember that the word enterprises is prohibited of use, I think. So I went with B, and that was right. But I
Well,
don't know if
the answer is B. That's not why though.
oh, it's not why? Oh,
The
why is
answer
why?
is B. Okay, when you're a sales associate, you can have your license set up as a corporation, either LLP or LLC, Inc. or PA. Remember that we talked about that?
Yes, the PA is the one that I was referring about.
Right.
Yeah.
So yeah. So when you do that, it can't be in anything but your name, PA, or your
Oh,
name, LLC. You can't put anything else in there unless you're a broker.
gotcha. Okay.
So when it says sales associate, it can only be LLC, Inc., PA, LLP, like whatever you set up legally, it has to be that. It can't be any other words than your name and that. Okay.
Got it. Okay. Makes sense. Appreciate it.
Yep. 75. Which statement is false regarding advertising? A, all advertisements must include the name of the brokerage firm. B, advertising includes flyers and promotional materials. C, the brokerage firm's address is required in all advertising. D, licensees may insert their personal names in ads provided they include their last name as registered.
Yeah, on that one, I don't know why, but I didn't see the false part. So I just went for the one that I was the most sure about. But now that I can see the false part, I know that the brokerage firm address is not required in all advertising. As a matter of fact, I think depending on what advertisement it is that you're doing, you are or not required to put the address of the business, as well as some other information.
Yeah, you gotta have the name of the business and the phone number of the business in Florida.
Yeah,
So
yeah,
it's correct. You don't have to add the address on everything.
on everything. But which ones are the ones that you most have the address of the business? I think it's either
For this,
internet. I think it's like internet or
yeah,
something like
it has to
that.
be on the web, any website,
Any website. That's what it is.
I put it
remember.
on everything because other states you have to have it on the logos too. So I
Amen.
put my logos I use on everything because the other states I want it all uniform.
Yeah, better be safe than sorry.
All right, let's take a 10-minute break and we'll come back and we'll finish off the review.
Sounds amazing. I will see you 1:30.
Okay, so let's get to number 76. Which statement is false regarding a corporation for profit that is doing business as a real estate broker? A, the broker must file the article of incorporation with the Florida Department of State. B, there must be at least one officer who is an active real estate broker. C, the corporation must be registered with the FREC. D, all stockholders must be registered with the FREC as inactive brokers.
Okay, so the way that I went about this one is by a phrase that you said that I'm gonna try to repeat as much as good as I can, and it means pretty much that in a real estate transaction, the person providing the funds does not have to be licensed. Essentially, if that's all they're providing is just the funds.
Yeah, but you're talking about corporations here. You're not talking about individuals. You're talking about
Well,
licensing.
yes, but in this case, the option that I chose happens to be D. All stockholders must be registered with the FREC as inactive brokers. That is the incorrect one. Like that is a false, essentially.
Yes, absolutely.
Yeah, because they're just stockholders essentially. They don't need to have any type of licensing. They're just
They
providing.
have no operation, right? They're not doing anything
Yeah.
operation wise.
There you go. So yeah, that's what I meant to say.
They're investors. Yeah.
Yeah, investors. Yeah, they don't need to have a license for that.
Yep. Exactly. Good. 77, a broker who changes the business address must notify the commission of the address change within how many days?
10.
It's 10 days. Yep. Good. Perfect, man. 78, in relation to section 1 of township 12, what's due north?
Oh, I had to have a whole section, imaginary one. I was like,
section 1 of township.
Yeah. So I knew.
Is it A, north, east, west, or south?
What is it?
So is it north, east, west, or south? In relation to section 1.
Oh yeah, I mean the answer is south. The answer is south. Yeah, for sure. But I had to like do the thing, and I was like, okay, so this one's here,
Yeah.
1 through 6, and then it comes right here. Okay, this is here. Great, awesome.
Good.
Yeah,
That's exactly how you got to do it. You'll see one like that most likely.
Yeah, that one was easy. I remember it very nicely. Yeah.
A man is a 70-year-old retired college professor. The local lender to whom the man applied for a 30-year mortgage denied the man's loan application, even though he has sufficient income from his pension plan and an excellent credit history. This is a violation of fair housing laws. B, the lender's actions are legal, is unlikely the man will survive the term of the loan. C, exactly. This is an example of redlining. D, the lender's actions violate the Equal Credit Opportunity Act.
The answer is D. The lender's actions violate the Equal Credit Opportunity Act.
You can't discriminate by age, sex, religion, race, right? Yep. All that, right?
Amen. There was something I wanted to ask you.
I think to 90, you can get a mortgage till 99, I think.
Oh, that's nice. It's pretty great. So is the fair housing laws referring to tenants more often?
It depends. Yeah, there's remember there's the fair housing laws are to tenants and owners.
Okay, tenants and landlords. Okay.
Yeah. Oh yeah.
Okay. That's I just wanted to kind of make sure that's.
Remember, not commercial though, right? The fair housing is all residential. Remember, not commercial.
Oh yeah. There you go. Yeah, fair housing is all it's all residential, not commercial. Okay.
Yeah. Okay, 80. Requirements of a valid deed do not include A, voluntary delivery and acceptance, B, good and valuable consideration, C, signature of 2 witnesses, D, signature of a competent grantee. Does not include.
Yeah, so the answer is D, because on that example you gave me, that pet that received the house, they didn't sign.
Yep. The grantor has to be competent, not the grantee, right?
Amen.
And the rest you need. So.
Amen.
81. An honorably discharged veteran who applies for a real estate license within 60 months of discharge is exempt from which fee? A, application fee, B, license exam fee, C, fingerprint processing fee, D, real estate recovery fund fee if collected in the license period.
The answer is going to be A. I want to go back to 80 whenever you have a second.
Okay. Yeah, A, application fee, right? The license fee is separate. The fingerprint fee is separate. The recovery fund fee, that has nothing to do with it. It's only the application fee. God, what are you talking about on 80?
So on 80, the good or valuable consideration, that usually refers to the money.
Right. Remember the amount that goes on the deed? Remember we said that's the amount that goes on the deed.
Okay. So if you are giving me a property, you would use a deed for that, right?
Yep.
Okay. And if that property is given to me for $0,
it'd be $1.
What is it?
It'd be $1.
Oh, it would be $1.
$1. You gotta have some kind of consideration.
Oh, I see. Okay. And the minimum is $1.
Yep.
Okay. You see, I did not know that, but I appreciate it.
Yep. You gotta have some kind of consideration. Yep.
Okay.
Remember, you were asking if the number goes on there. You could put the sale price. You can put whatever you want on there, right?
But it has to be a number other than 0. Okay.
82. Individuals who solicit mortgage loans, accept applications for mortgage loans, and negotiate the terms of new mortgages on behalf of a borrower are called A, lenders, B, finders, C, loan originators, or D, agents.
So a lender is the company itself.
Mhm.
A finder, I don't know. It could be anything. An agent, that's us essentially, or that's what I would be. So it would be a loan originator
One originator.
officer. I
Absolutely
think so it's
correct.
called. Yeah.
They're originators. Yep. Good. 83. The Florida Real Estate Commission is empowered by law to A, levy fines up to but not exceeding 500. B, impose prison sentences up to 60 days. C, assess damages resulting from breach of contract suits. D, reprimand, fine, and otherwise discipline licensees.
That is the one. It's gonna be D.
D.
Reprimand, fine, and otherwise discipline licensees.
Yep. And they can't prison you because they don't have the police power, right?
They don't, but they will get them to.
And they can't see that they can't do that. That's a court that does that.
Oh, is that what it is? Okay.
Okay, so look, 84. If a seller refuses to pay a broker her sales commission after the residential property is sold, the broker may A, file a vendor's lien on the owner's property, B, file a suit in the courts for her commission, C, refuse to permit the closing to occur, D, keep the binder deposit as just compensation.
I confidently chose A in that one, and I was so confident, and I just now figured, like,
Nope, it's after.
realized.
Yeah, you can't file it on the property.
I thought it was a vendor lien. It's not.
A vendor's lien is like if you're a roofing company and you're fixing the roof, or you build an addition if you're a company contractor and they didn't pay you. That's a vendor's lien.
Gotcha. So file a suit in court for the
Yeah,
commission.
you gotta sue them. You gotta sue them in regular court. Nothing else you can do.
Okay. All
You'll
right.
win. You'll win it because you have a contract, but you just gotta go through the court.
I did not know that.
Okay, let's go 85. If you have located a township number TS2 R4E, the township due south of that is
It's gonna be C. T3S, so Township 3 South, Range 4 East.
right, because it's just one down, right?
Just one
If it
down.
was one north, it'd be T1, right?
It would be T1, yeah.
And to the
T1
right and
R4.
left, same thing, right? Good.
That is correct.
86. In Florida, real property is assessed on January 1st of each year. And the property taxes become a lien on that property on A, January 1st the same year, April 1st the next year, C, November 1st the same year, or D, December 31st the same year.
I almost chose B, but the answer is A.
Say, yeah, yep. It's April 1st the next year is when the payment's due by, right? It becomes a lien on the first. Yep.
Yeah.
Good.
On April 1, they become delinquent. Is that what it is?
April 1, they become late delinquent. Yep.
Okay.
Which valuation assignment is exempt from US PAP requirements? A, appraisal for the purpose of refinancing a mortgage loan. B, appraisal for the report prepared by a certified appraiser. C, appraisal assignment conducted by a real estate broker for the purpose of a real estate sale. D, broker's price opinion prepared for a lender concerning a short sale.
It's gonna be D and E. D being broker's price opinion prepared for lenders concerning a short sale, and then E is CMA prepared by
right.
C.
Anything that's an appraisal needs to be on that form.
Amen.
So if it's an appraisal, it's on that form, right?
Yeah.
Okay. 88, for application and license purposes, a Florida resident is a person who has resided in Florida continuously in A, an apartment in Florida for 4 weeks, B, a Florida hotel for 6 weeks, C, a Florida residence for 2 months, D, a recreational vehicle for 4 months.
I'm just now noticing that I got that one wrong, and I honestly do not know why. So let me read it again. An apartment, they have reside in continuously in Florida in an apartment, a hotel, a residence, or what is the answer for this one?
Do you remember the time frame? What makes you a Florida resident?
I think it was Like 4 months, I think is what it was.
You got to live 4 months of the last 12 months in Florida.
Okay, so 4 months of the last 12. Yes. So it will be D, I guess.
It'll be D.
Okay.
It's a little tricky, right?
It's not a little tricky, sir. It's very tricky.
Yeah, you got 4 months. You got to be 4 months. So 1 and 2 are thrown away. Residence sounds good, but only 2 months. You got to throw that away too.
But what about the recreational vehicle thing?
It doesn't matter. You could be in a recreational vehicle in a lot for 4 months.
What is a recreational vehicle?
Like an RV, like a camper.
Oh, okay.
Mobile home.
Oh, okay. Well, I guess. Yeah, I was wrong about that, and I was very confident. I was like, easy. Even though I knew that it was 4 months, but it was like, yeah, it's a residence.
Yeah, no, not if it's less than 2 months.
Yeah,
less than 4 months.
All right, but wouldn't that recreational vehicle be their permanent resident for that amount of months?
Well, yeah, recreation is 4 months. That's what it is. It's a residence.
Yeah, okay, gotcha. But it has to be the 4 months part. Okay, got it.
Yeah, like a driver's license doesn't count. Voter ID card doesn't count, right? You got to be a resident for 4 months of the last 12, right?
Got it.
Okay, 89. A prospective tenant purchased a rental list from a broker and then rented a duplex that the list said included all utilities. The tenant discovered that the only water was included in the rent and notified the broker within the legislated time limit. The tenant is entitled to A, nothing unless the request for refund was made in writing. B, 75% of the list fee. C, 100% of the fee paid. D, no refund because the tenant agreed to rent the property.
Of course, the answer is not going to be D or A. 75% of the rental lease fee, it's only when the renter does not find a place to rent. And then 100% is when the lease is inaccurate.
Yeah. So what do you think it is?
100%.
It's 100%. C. 90. A real estate company represents a motel owner who wishes to list one of his motels for sale. The owner has told a listing agent that he does not want to sell the motel to any racial minorities. Which statement is true? A, because this is not a sale of residential dwelling under the Fair Housing Act, the listing agent may honor the owner's instructions. B, the listing agent may not refuse to show the sell of the motel to a minority buyer. However, the owner may refuse to sell to a certain individual if he sells the property for sale by owner. C, it is a violation of Fair Housing Act to abide by the owner's wishes. D, to refuse to sell or lease real property based on a party's race is a violation of the Federal Civil Rights Act of 1866.
The answer is D.
The answer is D.
Yep.
On a question like this, always the one with more detail in it is usually right. Right?
Makes sense.
Okay. 91. This is a math problem. So you want to skip over that for this?
Up to you. I mean, I got the answer, and I'm sure.
You have it worked out? Okay. If you're okay, let's do it.
I have them all worked out. Yeah, I have it all worked out.
So a property closes on June 10th with the day of closing charged to the buyer. The buyer is assuming the seller's mortgage loan with its principal balance of $227,500 at 4.5% interest. Which entry will appear on the closing disclosure?
Okay. So for this one, what you first want to do is you want to multiply. What is that I do for this one? Well, for one, you have to understand that the days are going to be 9 days to one party and then 21 days to another party. Yep, that's for one. And then you want to multiply, I think, 227,500.
Yep.
Times 0.045. And then
4.5%. Yeah.
Yeah, 4.5% essentially. And then that number you're gonna divide it into 365.
Yep.
And then you're gonna, so that's gonna give you the amount per day. And then you multiply it by the amount of days.
Yeah,
And
do you have it
that-
worked out? Do you have the numbers? Let's go over it real quick. Do you have them?
Yeah,
Let's go over.
I should have it somewhere over here. That is the 91. Let's see. I have it somewhere over here. Do I have it? Oh, okay, there we go. 91, 91, 91. 91. Okay, great. So the total that I came up with was for the day, it was 28.0479.
That's how you took 227.5 times 4.5% interest divided by 365.
Essentially, and that's the
It
total.
came up with, what was it? 28. Go ahead.
2804
Mhm.
79452.
Okay. And then what do you?
And then you multiply that by the amount of days. And that way you will know which one is which. For instance, if you multiply it by 21 days, it's gonna be
Yeah,
589.
that's for the buyer. You don't need that.
Yeah,
It's
I
asking for the
know.
seller. Yep.
I know. I still did it, but yeah, if you multiply it by 9 days, which is for the seller, it's gonna be 552.431507. So the answer is debit to seller and credit to buyer for the amount of 252.43.
That was on credit the buyer for now. So that's C, right?
That is C. Yes.
Good. You got it, man. Good job.
Amen. Thank you.
But if you did it the other way, you would have got that too, right?
If
you added the wrong one, if you added 21 days, it's this number up here, right?
Yeah, I'm sure. Yeah. I did not go that.
You gotta make sure you know the days right.
Yeah, the days. That's a big one there.
Let's look at 92. And then you can do the same thing. Go through the steps with me. The following taxes were paid at the closing of a new home. 1540 state doc stamp on the deed, 693 state doc stamp on the note, and 396 state intangible tax on the mortgage. What is the purchase price of the home? Did you get this one?
No. I did not get this one. I did
Let me
not
show
get
you how
this
to do
one.
it. Okay, so on the doc stamps, do you remember how much per thousand it is on a doc stamp?
How much per thousand?
Right. Remember, it was 70 cents or 60 cents, depending on the county.
Oh, yeah, you're right. So in Miami-Dade, it is 60 cents.
Right, but
Everywhere else, it's 70 cents.
right. So keep that out now. The doc stamps, to figure that out, you would take the sale price multiplied by 70 cents, right?
Mm-hmm.
So you're doing it backwards now,
Okay.
right?
Multiply
So you
by
70 cents divided by 1540. And it's going to give you $220,000. It's B. It's backwards math.
Okay. So for this one, I would have to
Okay, hold on. Watch here.
Yeah, please.
So if you have a house at $220,000, right?
Mm-hmm.
You got to multiply it, right?
Mm-hmm.
Well, first you're going to divide it by 100. Was it 100? Right? And then you take that times 70 cents, right? It gives you 1540, right?
Mm-hmm.
So we did it backwards now, right? So let's do it this way. You take 1540, right?
Okay.
Times 70 cents. It's, hold on, I hit the wrong thing. So 1540 divided by, yeah. So you take 1540 divided by 70 cents. And then you got to multiply it by 100, right? Because remember, you move the decimal.
Okay.
What's your sale price? You see that? Do you see the math? How it works?
Yeah, it was backwards. Yeah.
So 693 doesn't matter. 396 doesn't matter for this problem. You just need to know if the state doc stamps were 1540 and it was 70 cents, it's 1540 divided by 70 cents. And that gives you that number, but then you got to take it by 100, right? Because you got to move the decimal.
Yeah.
220,000, right?
Okay.
Make sense?
Yeah, it makes a lot of sense. So for Miami, just to double check, for Miami-Dade, I think you said it, Dade,
Miami-Dade would be 60 cents.
60 cents.
We
Yeah.
divide it by 60, then multiply by 100.
Then by 100. Okay. And then is it everywhere else?
Everywhere else is 70.
Okay. Okay.
Okay. Let's go to 93. A residential zone requires at least 7,500 square feet per lot. The developer is reserving 25% of the land for streets, sidewalks, and community center. The tract of the land and for development consists of 175 acres. How many residential lots are available? Did you get this one?
Yeah, I got it. I got it.
What'd you get on this?
For this one, oh, we're talking about 93?
Yep.
Okay. 93, my guy. 93. There you go, right here. 93. I got it. I got it wrong. I got 813.
Okay.
Somehow.
So let's look at it.
Yeah, you go ahead and tell me.
All right, so you have 7,500 square feet lot. The developer is reserving 25% of the land for streets, sidewalks, and community center. The tract of the land for development consists of 175 acres. How many residential lots are available? Okay.
Okay.
Where do you think you start here?
Well, we would start by, give me a second. A residential zone
let's look at it. It's 175 acres.
No, I'll tell you. I'll tell you. I just have to read it. You have to read it. I promise I got it.
Okay.
So a residential zone requires at least 7,500 square feet per. Okay, we don't care about that for now. The developer is reserving 25% of the land for streets, sidewalks, and all that good stuff. Okay, the tract land for the consists of. Okay, great. So the first thing we got to do is 175 times 640.
No.
Right? No.
What are we trying to figure out?
We're trying to figure out how many square feet there is in all this. Yeah.
Right, square feet, not acres. Acres is 640.
Yeah.
Square feet is 43,560 per acre.
That's what it was. Yeah, that's what it was. I think I did it that way.
So watch here. Look, watch. 175 acres.
Yeah.
Minus 25%, right?
Oh, you're taking 25% out of that. Okay.
So you have 131.25 acres. How many square feet per acre?
Square feet per acre, 53.
No.
43? 43,6.
43,560.
560, yes.
So times 43,560. How many square feet per lot?
7,500.
Divided by 7,500. How many lots?
The answer is B, essentially.
And the answer is B, 762.
Got it. Let me go ahead and take some notes on that. So we got the 175, and then we multiply that by 0.25, which is the percentage, so we can get that out of there.
You got to subtract it. You subtract, right? Because that's going to be the streets. That's not going to be buildable.
I agree. So I can just do it by 75. If I do it by 75.
What do you mean 75?
Instead of multiplying it by, because you're doing it by the percentage. I'm trying not to use the percentage on that.
You have to use the percentage though.
I know, but in the way that you're doing it in the calculator, you hit the percentage sign, and the way that I'm doing it, it's hitting the multiplication sign.
As long as you get this, as long as you get the same answer.
Yeah, and I will. Yeah, and I will. So let me just double check, because I want to make sure I got that one right. So I got 175 times 0.75, and that's gonna be 131.25. What's your equation, by the way? And then that amount we multiply it by 43,560. answer is gonna be 5717250, and then that divided by 7,500. It's gonna be divided by. Okay, I got it.
Make sense? You got,
Yeah.
so you did the other calculation, but you got it now. You good?
Yeah, I got it.
Good.
Thank
Let's go to 94. A prospective
No.
borrower is applying for a conventional fixed loan. The borrower's monthly gross income is 6,500. The borrower's projected P is 1372, and the PMI is 150. Based on the credit report, the borrower has the following long-term obligations. What is the borrower's total obligation ratio, and does it meet the lender's required threshold for a conventional mortgage?
All right. Yeah, that one. That one I did not do. I do have the result for it, but I.
So let's look at it. Okay, so income, we know 6,500. The pity is 1372, right? Right, 1372. PMI is 150. Right? The car payment is 400. The student loan is 390. And the credit cards are 250. Okay, so their debt is 2562. You divide that into 6,500. It's 39.4%. Okay. So do you remember what the ratios are?
Yeah, I do remember that. But before we get to that point, so you added up all their expenses, and then, but let me ask you this: isn't PMI private
Mortgage insurance?
Mortgage insurance.
Right.
So that's not added to the PD, is it?
What are they asking you? No. What are they asking you for? What are they asking you for right here?
They're asking me for the total obligation, I think is what it is.
Right. They're not asking you for the housing expense ratio. Housing expense ratio would be the PMI and the pity. Right?
Okay. I thought that the
total obligations is add all these in.
Got it. I thought that PMI was already added in PD,
No.
in the I.
Principal, interest, taxes, insurance. PMI is the insurance policy you're paying if you borrow more than 80%.
Oh, okay. Got you. So in PD, it's the house insurance, the home insurance.
Yeah, the home insurance. This is the mortgage insurance.
That's what I had an issue with, because I thought it was referring to the same insurance, and I'm like, I don't need this data.
Right.
And I just crossed it.
Yeah,
and that's how
you need that one. So in the her, you have this. In the tour, you must add these all together.
Okay, so I might have them all together, and then
you take the total, divide it by 6,500, and it gives you 39.4%. And the answer is B. It's 0.3941%, which you see on the screen. So 39.4, and it's greater than the threshold for a conventional loan. Right?
Okay.
So it's over 38, right? 38 is the percent. So it's higher. It would not qualify.
It would not qualify because the amount is greater than
higher, right?
39. Okay.
So it's B. Good on that one?
Yep, good on that one.
Good. 95. You are appraising a 5-year-old single-family home. The livable area is 60 feet by 50 feet. The garage is 24 by 20. According to figures obtained from cost estimating service, the base construction cost per square foot for livable is $103 and $92 for the garage. Calculate the reproduction cost of the new structure. Did you get this one?
Of course. Yeah, this one's easy.
So what did you get on this one? How'd you do it?
How did I do it? So I multiply 60 by 50, which is the livable area. And then I got that result aside, and then I got the garage area, which is 24 multiplied by 20.
Right. So you had 3,000 for the house, right? 3,000 for the house.
3,000 for the house.
Or 60 by 50. What was that? What did it total up to?
So 60 by 50. I think that came up to be 309,000.
So 60. Here, hold on. 60 by 50 is 3,000 square feet.
Yeah, yeah. So
And
3,000 square
you
feet.
take that and multiply by 103,
There you go. There you go. That's what I did.
right?
Yeah.
And that gives you 309,
309. That's how I got to 309.
right? And then you take the garage 24 by 20, 480
And then multiply
times
that
92.
92.
So you take that plus 309, 353, 160. Your answer is C.
Amen. That's it. That's it right there.
Okay, 96. A homeowner originally purchased a new home for 244.9. During the period, the ownership of the homeowner spent 27,000 in capital improvements, and the homeowner sold the home 16 years later for 329.9. The homeowner paid a brokerage a fee of 6% of the sale price and paid the other closing costs totaling 27.50. What are the homeowner's capital gains from the sale?
The answer is going to be B for that one.
Did you get it?
Yeah, I got it.
Break it down for me.
Of course. So on this one, what I did was I got the total price, which was 27. Wait, wow, how do you find that? I know I found it. Okay. So they purchased the property for 244,900.
Right.
And then okay, that's what I did.
So you
So
bought
I
it for
added
244.9. That's what they bought.
yes,
Okay.
and then I added a 27,000,
Right.
and that was the total investment of the property. Wait, no, you added the plus sign.
Yep.
Okay.
271.9.
Yep. And so that was the total investment on the property.
Right.
And then I got the sale price, which was 329,900.
So at least 58,000 profit.
That's how you did it. You're right. I did not do it that way.
Right. And then you got to remember they got a commission, right? They sold it for 329.9, right?
Yeah.
So you have 58,000 profit, right? But 329.9,
There you go. That's how I did it.
they have a commission amount of 19,794, right?
Yeah.
So you have $50,000 profit. You had a commission of 19,794, and they had closing costs of 27.50.
Yeah.
So you have to take the 50,000, right? Minus 19,794 minus 27.50. Do something here. I'm not calculating something right here.
I think it was 58,000.
Yeah, it was 58,000, I think.
Okay, so 58,000 minus 19,794 minus 27.50. 35,456 B.
Yeah. I did it a little different. but it came.
You got to the same answer.
Yeah, it came to the same.
Doesn't matter how you got to the answer as long as you got to it.
Yeah, amen.
But you want to do it the simplest way. You want to take the least amount of time.
I think my way was simpler though. I really do. I really do.
Yeah, whichever works, man. It's not. There's no.
Yeah, it was great.
All right, so let's look at 97.
97. That one I had a lot of fun.
Yep. A homesteaded property is located in Jupiter, Florida, in Palm Beach County. The property has been assessed at 185. The city tax rate's 8.8. The county's 9.3, and the school board levy is 6.5. The owner is a widow and has qualified to receive homestead exemption. How much will the owner pay in property taxes? Remember, on this it's 500, not 5,000, right?
Yeah.
Right now on the test it's 5,000.
Yeah, I got it.
You got this one right?
Yeah, I got that one right. I got that one very right. It took me a lot of scratching because I was doing it quick.
Want me to go over it with you quick? Let me go over it real quick.
But I got it.
Just go over it quick. So you have it.
Got it. I can do it very quickly, yeah.
Yeah, so we have a homesteaded property. I'm gonna make notes here so I can do this too. So we have a homesteaded property. It's 185,000, right? 185,000 altogether. You have school and county, or school and county and city, right? So the school taxes, she qualifies for homestead. It's over 75,000. School, you take 25,000 off. County, you take 50,000 off, right? County and city.
Yeah.
Okay. She's also widow. So minus 5,000 of each, right?
500.
Or 500, right? 500 for this calculation, right? Okay. Because remember, January 1st, 23, it goes to 5,000. But on this calculation, it's 500. Okay. So you have the mills. Okay. You had the city is 8.8. And you had the county is 9.3. You can add those together, right? So 8.8 and 9.3 is what? 18.1. So 8.8 plus 9.3, 18.1, right? That's your mills. And then your other mills is 6.5, right? Okay, good. Okay, so what you have to do now is you take your 185, right? Let's do the county first. You take your 185 minus your 50 minus your 5, right? 500 on this one. And your taxable amount for the county is 134.5. Now you take 135 and you got 18.1 mils. You got to move it decimal 3 times. So you take it times 0.0181. And that's going to give you taxes of 2434.45 for city and county. Now, you must go over here and do your school now. So you have 185 minus 25,000. That's your maximum for school. Minus 5,000, right?
500.
Or 500. Yep. I keep saying 5,000 because that's what it is.
Right.
So 159.5. And you're going to multiply that by 0.0065, right? Because you're going to move that decimal over for the mills, right? 0.0065. And that's going to give you 1,036.75. You're going to add 2434.45. 3471.20. What other is that? B? And that's your taxes. 3471.20 for 97.
That's it.
That calculation.
That's it.
98. A developer purchased 3 oceanfront lots, each measuring 75 by 110 for $20 per square foot. The developer later sold the lots for $200,000 each. What was the developer's percentage of profit made on the sale for 3 lots? Rounded a percentage.
Got it. So the answer for that one was C, 21%.
21. Good.
Yep. The way that I did it, pretty simple.
Yep, go ahead. Let's do it. I'll do it on math here on the screen so we have it.
You got it. So I got both the dimensions of the property. So 75 times 110. And then I multiply that by 3, which is, there's 3 lots of those.
Right. So 8250 times 3, right? 24,750.
That is correct. And then I multiply that by 20, which is the amount of dollars per square feet.
Yep, so there you go.
Yep. And then that amount, I subtract, I pretty much got 600,000 minus that amount.
Right. 295?
No. So the amount was, it was.
Oh, wait, I'm sorry.
Yeah. Okay.
So 600 was the price. So it was 600 minus what? I'm sorry.
Yeah, 600 minus 495,000.
Right. I'm sorry.
You're fine.
So
You're fine.
105,000 is what he made, right?
So now, yes. So now we divide made divided by paid.
Mm-hmm.
And so essentially we got the 105,000 divided by 495,000. And that equals 0.21, which
so 21%.
21%.
Bingo. There it is. Did the math.
Amen.
Good job.
Thank you, sir.
99. A seller listed a home for 200,000 and agreed to pay 5% commission. The listing contract required the listing office and the selling office to share the commission on a 50-50 basis. The home was sold 4 weeks later for 90% of the list price. The listing broker paid the listing associate 50% of the listing office commission. and the selling broker paid the selling associate 60% of the office commission. How much commission did the selling sales associate receive? So we don't care what the listing got. We care what
Yeah,
the
we do
selling
not.
got, right?
I crossed it out. I crossed it
Right.
out. I was like, I'm not even gonna look at you.
So let's look at this problem, right? Let's look at this. So you have, and with the calculator, the seller listed a home at 200,000. It's 5%. They sold it for 90% of that. So you got to take 200,000 times 90% to figure out what they sold it for, right?
Yep.
So they sold the house for 180, right? The commission was 5%. I hit the wrong button there. Hold on.
No worries. 180.
So 180. And the commission was times 5%. So the commission amount was $9,000. Now that commission amount got split 50-50, right?
That is right.
So you got to take that divided by 2.
That's right.
Oh, why did it do that? So it's 4,500, right? To each broker. Right?
Yeah,
So each broker got 4,500. I think the
Yes.
battery's going dead in my mouse. I gotta put it in the battery.
I was saying, I was like, what?
Yeah, so 4,500. Now, the listing office got 50%, the selling office got 60%, right? So you see how they put 4,500 there? If you can mess that up, right? Because it's in the answer, right?
Yeah.
Now, who are they asking? How much did the selling sales associate get? The selling associate got 60%. So you're going to take this times 60%. $2,700. And the answer is A.
$2,700.
$2,700. Right? Good. 100. An
100.
appraiser assigned the value, the following weights on 3 adjusted comps. Comparable 1, 322.5, 40%. Comparable 2, 319, 35%. Comparable 3, 312, 25%. Did you figure this one out?
Yeah.
Very easy.
Right?
Right?
That one very, very easy. Very, very easy. You just get the price of each comparable and multiply it by the
So
percent.
let's say you have 322,500 for the first one, right?
Yep.
Times 40%. Right? Times 40%. So the amount of that one is 129.
129.
And you got 319 times 35%, right? That equals 111, 650. And then you got 312. Oop. 312 times 25%. And that's 78,000. You did 78,000 plus 111,650 plus 129,123. 318,650. And your answer is D.
That's it.
318,650. And that is your practice exam.